and you can see this in lines 16 through lines 20, effectively the address that they are the rightful owner, that they're not currently under a rental agreement, and that they request that the unlawful tenant be removed within 1 day. So effectively, they are being able to provide this to the clerk of the court, so that essentially it effectively puts everyone on notice that that home is not available for rent. And if for some unknown reason a squatter is able to take possession of that rent, and by the way, I use the word squatter just as a general term, is able to take possession of the home, that this is something that would be used dispositively by the sheriff or whoever the law enforcement that's going there in order to be able to determine the rightful ownership and whether or not the rightful tenancy of that home. Mr. Chairman, that's essentially the bill.
I have a question. Who would have access to the docket or whatever the clerk would keep on that?
Mr. Chairman, I do not pretend to. I know that the clerk of the Forsyth County Courts are here, and he may be able to provide a better, more clear answer than me. But my understanding is there is no restriction to being able to see the records that within the clerk of any court within our state. So this would not be subject to any type of confidentiality or any type of shield. As a matter of fact, I would rather be just the opposite. I would like for this declaration that you're not renting your home to be something that is, I'll say, publicly available.
I think some of the current concern I've heard about that is that it would create a, come rob my house docket kind of thing.
So, Chairman Gunner, if this went into effect and became law in the state of Georgia, I would use it. That doesn't mean that I left. It just means that I am putting basically the county of Forsyth within the state of Georgia on notice that I don't rent my home. And if I happen to leave for an extended weekend, maybe up into the mountains where you represent, when I get back after 2 or 3 days,
Okay, so the idea then is not for just vacant housing. It's for where you live, and just have it out there that you're not renting it out to anybody.
Exactly. In a perfect world, I'd love to get to the point where if we have a closing on a house, as an example, whether or not it's your primary house or whether or not it's a second or third home, that maybe this is something that we proactively put in there asking the individual buying the home, do you want to rent the house? And if you don't, just go ahead and say so now, no different than what we do with the voter law in terms of just, in a sense, opting in or opting out. But again, that's not what this bill does. This bill would actually allow folks today to be able to be proactive with their clerk.
Gotcha. All right. Thank you very much for that explanation. Any other questions from the committee? I don't see that anybody signed up for it. Is there anybody here that wants to speak on 1153?
Judge, she put her button in.
Oh, I'm sorry. There we go. You're on.
On line 19, you refer to an unlawful tenant, and I apologize to the committee. The last committee meeting we had on Mr. Seaball's bill, I was totally confused because I was going back and forth between the intruder statute and the tenancy statute, and I never got it straight. Are you amending the intruder statute here in section 1?
No, I think I know what we're doing in terms of tenancy and the tenancy of a particular home. And that's really what's at question, in my opinion, Representative Oliver. Basically, the rightful tenancy of a home. Now, intruder starts to get into, again, even though I'm admitted to the bar, I don't proclaim myself an attorney. I'll let people who are smarter than me do that. But my understanding is the intruder section, which is in the criminal side, that's not what this is referring to. This is referring to the tenancy.
But you're setting out an affidavit that says he's an intruder. But
Correct.
then you're confusing it on line 19 by saying he's a tenant. And that's my problem in going back and forth with these statutes, the reason I have trying to clarify that. Because an affidavit that says, under the intruder statute, you go and you file an affidavit with the sheriff and you say, this guy is basically a trespasser, he has no right to be there. And then the person in the house, we'll call him the squatter, answers by affidavit. That's the procedure. But this affidavit is filed with the clerk of court, which is another way other than eviction. So why do we have a clerk of court affidavit versus a sheriff's affidavit? Am I still confusing this in my mind?
May I? Oh. Yeah. So I'm sorry, Representative Hung, if you'd like to answer, and then I'll answer after.
Is this the
after you.
intruder statute we're amending, or is it a new statute?
It's not. So I had the same question. So line 19 talks about what you're going to be putting in the affidavit, and you can use that affidavit in a dispossessory proceeding. So it's not necessarily you're saying now there's an unlawful tenant and they have to be removed. You still have to go through the dispossessory proceeding. Is that correct,
Correct.
Chairman?
And if you also go down to lines 39 through 41, my belief is that makes that clear.
I'm just, forgive me, sponsor and Mr. I don't, it's not clear to me about what's an eviction and what's an intruder procedure, and why is an affidavit, if it's an eviction procedure, what, is the affidavit part of the writ of a petition for eviction in the magistrate court?
If I may, again, Representative Oliver, if I could turn you to lines 14 to 15, we're talking about stating the intention to not subject such property to rental agreement. And again, I don't practice, so I do not pretend to know all the eviction proceedings, but this is, to me, an eviction proceeding is post. This is pre. This is a presumptive, call it, statement, an affirmative action being taken by the homeowner saying, I don't rent my property. This is a declaration of that. Now, I would argue with you, if it's your homestead, as you know, other than for 14 days in the Augusta rule, you shouldn't be renting out your homestead. But that's another discussion for another day. But
Affidavits filed with the clerk of court are
Right.
not, are public record, but they're not published based on our lack of uniformity of publishing pleadings. So if I'm in DeKalb County and you file an affidavit with the clerk that says you don't rent a house, I don't know, the Forsyth clerk may or may not have that available to me online.
But I would then state, Representative Oliver, the question becomes is, do you, let's assume for a moment you're coming to Forsyth County where I live, is it your intention to take possession of my home?
Certainly not your home, but. Yeah, I was gonna say, it's above my pay grade to take. I give up.
I do have a question. Thank
Go
you,
ahead.
Mr. Chair. And I think the confusion lies that the affidavit specifically is talking about the intention to not subject such property to rental agreement, but now in line 19, you're talking about a tenant and going through a dispossessory proceeding. So I think maybe in those lines, you're basically saying this is not a rental property. So therefore, whoever is in there is a trespasser versus a tenant. In the words of, because if you are going through a dispossessory proceeding, you have to establish a landlord-tenant relationship. And so I think maybe, do you have an answer to that?
Yes. So I asked the same question. So if you look at line 19, unlawful tenant, I asked, should it say request that any trespasser? Blah, 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 blah. And they said, no, given the fact that we're going into a dispossessory proceeding, they're an unlawful tenant because they have taken a claim to your home, claiming some type of either rental agreement exists, some type of verbal agreement exists, et cetera, that this individual, quote, has decided to rent my home in Forsyth County. And that's the basis for their tenancy of my home. So the way that I understand it, and Representative Hung, again, I am not an expert in tenancy law, we needed to say unlawful tenant there to move into the dispossessory proceedings to allow us to be able to use this affidavit as dispositive to allow the sheriff or whatever agency is going to go ahead and remove that individual from the subject home.
And I agree with you as the law stands right now. And I think we're getting confused because we've had so many other bills before us that may change that. But I think as it stands, the language here will also allow this homeowner to be able to go through the dispossessory proceedings because they would have to in order to remove the unlawful tenant. So if that clears it up.
Hi, Representative Oliver.
I used to be the dispossessory judge. It was way too long ago for me to remember all this. But it seems to me like your effort is preventative. And it seems to me that your affidavit would be a very helpful addition to an intruder procedure before the sheriff or eviction procedure that you may choose to follow. I just don't think this is a third procedure you're initiating that leads to a writ of eviction. Do you think this leads to a writ of eviction just by filing the affidavit?
I believe that what we're trying to do, just for clarity, I believe I am stating the intention to not subject the property to the rental agreement. I am not trying to change, and I mean this intentionally, my intent, I'm not trying to change all the other law that exists around tenancy, rental, eviction, and everything. Our feeling, or I'll say mine, I shouldn't say our. My feeling was providing the homeowner the ability to provide notice, proactive notice, gives that homeowner greater standing in whatever proceeding we're going to be going through, whether or not it's dispossessory or any other, stating, I declared, 6 months ago, 6 years ago, whatever it may be, I do not rent this home in Forsyth County. So this should be used, I believe, just like it says in 39 through 41, as effectively evidence that, no, said individual does not have lawful possession of my home, notwithstanding all the other things that need to occur to your point. And again, I can't reel those off the way that I could, a former judge could.
Oh, you're asking me to reel it off?
You too are a former judge, even though I do declare that I call you judge all the time.
Who never did a dispossessory in his time as
But
judge.
for the record, is a much, much higher level than I was a former judge. Much, much higher.
Maybe we
What
look
do
at
you
Judge Scoggins then.
Sharing this one. I like your idea. I understand the issues we're having with squatting in the state. What procedurally do you think would happen if what's the process you envision if someone decides that now they do want to rent their house? How do we undo the affidavit? Do we come back into another affidavit saying, all right, I've had a change of work and now I'm out of town, and instead of selling my house, I'm going to rent it? I guess that's just my question is, once the affidavit's there and it's been filed, if circumstances change or a house is sold or whatever, how do we kind of undo that?
Right. So a great example would be, I don't like my children enough to let them just use my house, but I might rent it to them one day. Oh, come on, that was funny.
I was just thinking about your poor kids.
Yeah, but no, in all seriousness, my understanding, and again, I was trying to avoid it becoming 97 lines instead of the limited bill that it is right now. My understanding is that there is a process that already exists with the clerk of the courts within all the states in terms of, in a sense, to your point, I'll use your phrase, reversing an affidavit. So whether or not the clerks use some type of affirmative action like another affidavit to reverse that or some other process, my understanding was that the current process exists. It would allow you to be able to reverse, and I did not want to, I'll say, upset current processes that have been probably going on, maybe not 100 years, but I'll just say for decades. If there's a feeling amongst the committee that we need to be prescriptive in here in terms of how you reverse that, to your point, my wife and I decide to, leave for a year, and now we do want to rent my home, and I do want to reverse it out. I hope that Clerk Allen, my clerk in Forsyth County, would have a way for me to reverse it and be able to get that on. But again, my understanding is all the clerks have a process, not just for this instance, because it says this isn't in statute, but for all instances in terms of reversing affidavits.
Is that true, Greg?
I'm thinking.
All right, and I don't want to ask you to testify while you're sitting there. Maybe you'll come up at some point. Okay.
But again, when I say I'm happy to put it in if we need to put it in order to make it clear that the intent of the legislature is to allow you to change your mind. I mean, to your point, I could get a job on an oil platform for the next 3 years, and I just want to rent my house while I'm doing the gig in the Gulf of Mexico. Yeah.
Okay. Any other questions? All right, seeing none, what's the will of the committee?
I'll make a motion to pass to start a discussion.
All right,
Second.
all right, got a motion and a second. Any discussion, any amendments anybody wants to make?
I'm curious as to what the clerks say about procedurally, Mr. Chairman.
It's not a rule.
Just because I don't know if I need an amendment or not.
And we got people watching us, so if you would introduce yourself and then talk to us.
Greg Allen, Clerk of Superior Court in Forsyth County.
Okay.
I was, as y'all were talking, I was thinking how this will be done. We can't file a cancellation, but I believe this will be filed with whatever deed is filed on the property that he owns. And the affidavit would go in, maybe an amended affidavit saying, that's my initial thought.
Okay. Would you have, I know like on, when you're canceling a security deed, you have notes stamped on it as to where another document is?
Yes, it would be cross-referenced.
It would be
Yes, sir.
cross-referenced, like, so you could do that with these affidavits. So he could file a later affidavit or something else, a declaration or statement that he no longer keeps his house empty, that he now rents it out, something like that.
If this proper to file an amended affidavit, we would cross-reference it with the deed that the original affidavit was filed with, yes.
Okay. Does that help any?
So you don't think we need to do anything with with that language on that point? I understand you may have some thoughts about other provisions of the bill, but
In 5 minutes of thinking about it, I can't say yes or no, but I think it's something we could address pretty easily once we get some people's minds on it and talk with the authority about how we do that.
Just from my experience years ago, I saw all kinds of stuff in the dockets where they're filed that helped clarify what was going on with a piece of property. So, okay. Representative Silcox.
Yes, I'm just curious, what effect do you think that covenants and restrictions, if someone's in a neighborhood, for example, that prohibits renting your house, would that confuse this issue, or you think that would be a problem?
To me or the clerk?
To the clerk.
It's getting more in a legal arena that you
Yeah.
judges and attorneys might be able to answer better than me.
Yeah, I mean, I just think this would be confusing. Haven't practiced in that area before. Just if you have covenants and restrictions, those usually supersede, but this would just be a question of law, I guess.
Well, I think first of all, the homeowner would still have to abide by the restrictions. That would be the first thing. If it allowed for him to file this affidavit, he can do that. If it didn't, then he would be prohibited.
Mr. Chair, could I comment?
Yes, sir.
We had it occur in one of the HOAs that are in my district. That HOA doesn't permit renting. However, the person, claimed that they had a rental agreement, and of course, the homeowner had left for about a month during the summer last year. I don't know where they went. It's not irrelevant. It's not relevant. So the fact is, they came back, and even though they were claiming the exact same thing, my HOA doesn't even allow me to rent. They still had to go through this laborious process. I think giving that homeowner who sits in that HOA, I'll say an additional layer of Kevlar to be able to state inside of the proceeding that not only does my HOA not permit it, but I also have this affidavit filed, I think continues to bolster their case that the individual is an unlawful tenant within that home.
Okay.
Representative Oliver.
Mr. Clerk, what are you going to charge somebody to file this affidavit?
$25.
Okay.
All right, Representative Kelly.
And I apologize for coming in a few minutes late, and so I'm trying to now I'm looking at the form of the affidavit. Where you say request that any unlawful tenant be removed within 1 calendar day. Have we got any feedback on whether that's possible, or I know we've heard of some of these dispossessions and things taking extraordinary amounts of time, and I'm just wondering what the effect.
Well, if the idea around the word was we request it, not command it, direct it, require it. The reason why is given, and I know you know this, Representative Kelly, with the 159 counties having, I'll say, a myriad of different capabilities of executing this, some can execute within probably 6 hours. Others may not execute for 6 days, and unfortunately, some may not execute for 6 weeks. So the idea is to make that request as one day, knowing that unfortunately, just due to the, I'll say, availability of resources to be able to remove that individual. If this was a commercial contract, I would have put best efforts. But unfortunately, I'm told in the statute I can't put best efforts.
And we don't think that we could be exposing local governments for any liability if they're not able to comply with that, you think?
Again, now we're getting into a part where I'm not too confident in answering that just because I don't practice. But again, it's a request. And I don't believe we can give any homeowner confidence, even if I was to put in there 1 month. I mean, I'd like to think we could require this to be done within 1 month, but again, I'm still not convinced of that, given, to your point, the testimony we've heard around Representative Seabaugh and some other folks just this session.
Gotcha.
Representative Reeves.
From some experience on another bill that I think we'll be hearing on, intruder and unlawful squatter, I think would line it up with a bill that we may hear later.
Does that help anyone? No? All right.
She and I normally have to go into a room. We discuss it real quick. We go back and forth on what we agree on, what we don't agree on. Then we find common ground.
Yeah.
We're just not able to get into
We're
a
just
room
not
right
able
now
to
and do that.
right now, yeah.
Right.
All right. I have a motion and a second. Any further discussion? Any amendments? Hearing none. All those in favor of the passage of the bill, say aye.
Aye.
Boy, that was weak. All those opposed, like sign?
No.
Okay. The ayes have it. All right, your bill's out and going to rules.
All right. Thank you. Thanks, Rick.
All right, next. House Bill 1244.
This is the one where we get to have fun on, right?
Okay, yeah, go
All
for
right.
it.
Okay. All right. Mr. Chair and members of the committee, I present to you 1244 LC 481164, just for confirmation. Okay. If it's possible, Mr. Chair, would you like for me to introduce it and then introduce the three
If
witnesses?
you want to bring them up, that's fine.
Is that okay?
Yes, sir.
All right.
If they're going to be testifying, they're going to need to get near a microphone.
Yeah.
So one over here and then
I
yeah,
promise
one on
not
the
to breathe
corner
in.
there. Sorry to put you so far away. Or y'all, I tell you what, you could share that microphone if you want to sit in that yellow seat.
I don't know if you want to or not. I have Ebola.
Yeah. All right. Go ahead.
Mr. Chair, would you like them to introduce themselves, or would you like me to make my comments and then
Make your
introduce?
comments and then
Okay.
we'll get to them.
All right, thank you, sir. All right, members of the committee, I bring to you 1244. I want to give an overview, and then I'd like to hand it off to the individuals who are joining me up on the dais today. At the end of the day, the Georgia Intellectual Property Protection Act goes towards, I think, both issues of, I'll say, ensuring that our economy continues to grow unfettered, ensuring that our economy continues to be a place of innovation, making sure that we're protecting our companies' investments, our workforce, and then it also goes towards, in some way, shape, or form, it also goes towards national security. The importance of this can't be understated in the sense that we have to be able to ensure that whether or not a foreign actor or whether or not a domestic actor is using the judicial system to be able to pierce the veil, to be able to get to discovery that they would not necessarily be entitled to, is absolutely imperative from a business standpoint in ensuring that our Georgia businesses maintain, hopefully, the competitive advantage that they've been able to create over the past decades, if not centuries. If you think about it, many businesses make a conscious decision to either are they going to submit a patent or are they going to remain with a trade secret. The greatest example of that sits as an Atlanta-based company, and that example, probably for the entire world, is the Coke formula. The Coke formula has never, ever been publicized. It's never been sat into the USPTO. It's always been a trade secret, and rightfully so. The founders of Coke made a conscious decision to basically store it and make sure that it was protected to ensure that they maintain that competitive advantage within the beverage industry. There are so many other examples that I can give with Georgia-based companies. Lockheed Martin, for instance, who not only we are proud to say is a Georgia-based company, but also does a significant amount of work for our Department of Defense. Though I've never been inside the inner sanctums of Lockheed and looked at their entire IP treasure trove, my hunch would be that yes, they have absolutely submitted to the USPTO for a series of different patents. But my hunch is there's a series of different trade secrets that exist within the sanctum of Lockheed Martin that not only would they not like to be public, but they also want to ensure that none of our foreign adversaries ever got control of that intellectual property. It was with dismay that I learned that our system of justice, one that is supposed to balance, one that is supposed to be blind, is somehow being permeated and prostituted for the fact that of people coming after our company's intellectual property. Again, potentially causing irreparable harm from a financial position to our companies and also causing potential workforce loss. In addition, the idea that our national security could be threatened by this is absolutely unacceptable. So as I was going through and learning more and more about third-party litigation funding, one of the things that came to me was it was imperative for us to be able to make sure that there was transparency and transparency for the court. I know we have several judges that sit on this committee, and the idea of being able to provide those judges with greater transparency in terms of who are the actors within a lawsuit. I'll be frank. We all know I joke about the fact that I'm admitted to the bar. I've never been inside of a courtroom, thank God. I don't practice, but I know this. If I ask the average Georgian about a lawsuit, my hunch is they're going to say there's one side and there's another side. There's a plaintiff, there's a defendant. In a civil case, in a criminal case, there's the state, and then there's the defendant. I learned so much more researching for this bill because I didn't realize just how many players were actually sitting in that courtroom, whether or not they're physically there or not. The influence that these entities are having over our system of law, I think is basically not creating an even scale. I'm not sure if Mother Justice is blindfolded or not. And I'm definitely not convinced that plaintiffs are being informed. I would have assumed that a plaintiff would be informed proactively if there was suddenly going to be financing required of this particular lawsuit. It's no different than being in business. If you need working capital, you need CapEx, R&D, you name it, you know who the source of your funds are, you know where it's coming from, and you know the terms. There are instances where these plaintiffs are not aware of that. There are instances where the plaintiff is being asked post-verdict or post-settlement to actually pay out. Think about that. You thought you were filing a lawsuit because you were harmed, and yet you're getting a bill. What this bill does, and what I hope to be able to present and continue to plead with this committee to do, is to ensure that we just have transparency. Ensuring that the arbiters of justice have all the information they need to be able to determine what is discoverable, what's not discoverable, who should have access, who should not have access, who should control the proceedings. I'll give you the Cliff Notes. I think the plaintiff should make the decision. It's the plaintiff who was harmed, whether that be in a single or a mass tort. I asked the committee to consider that as we go through this because I know there's differing opinions on the committee, and I respect that. But I hope that the overall and arching goal of trying to find true balance, true transparency, protecting our businesses, protecting the intellectual property, protecting our workforce, and ultimately protecting our national security are paramount as we go through this discussion. Mr. Chair, those are my opening comments, and if it's okay, I'd like to ask the three gentlemen who have joined me to introduce themselves.
I have a question for you before
sure.
we get there. Representative Kelly.
Thank you, Mr. Chairman. Chairman Jones, I appreciate the stated intent of protecting national security, protecting trade secrets. Do you know maybe how long litigation funding companies have existed in the legal system? How long they've been around?
My understanding is they started to crop up somewhere in the early 1990s, and then it became, I'll say, greater institutionalization of that, which is not unusual for, I'll say, a Wall Street product, hedge funds, etc. Look, I love capitalism. God bless Gordon Gekko. And at the end of the day, I think the idea of securitizing this type of funding, I get it. My goal is not to stop that funding. My goal is just to have transparency on it. But my understanding is, say, 30 some odd years.
So around 30 years these have existed. And I think one thing we can certainly agree about with this bill is Coca-Cola is probably, and the formula for Coca-Cola is probably one of the most valuable, formulas that exists in the world. Certainly the most profitable mix of water and sugar and spices. I mean, figuring that out would be a gold mine for somebody. Mm-hmm. And yet these have existed for 30 years, and Coca-Cola is still safe and locked up. And so my kind of question is there a real threat with getting those trade secrets? Because if a foreign actor for the last 30 years could really access Lockheed Martin's data by using litigation funding, which has been here for 30 years, I would feel like we already had some national security breaches, or there'd be another version of Coca-Cola somewhere. And so that's my concern with whether, I share the same concerns you do about protecting trade secrets and our national security. But I wonder if there's a little bit, the risk I feel maybe a little overstated.
Representative Kelly, so first of all, as always, I appreciate your candor, and I appreciate your willingness to work together. I just spoke to a bill on the floor about an hour and a half ago on a subject matter that, though existed, not for 30 years, but has existed, but now has become, in my mind, a tantamount threat to election integrity. I think in this case we see the same thing. I think that ultimately we're starting to see a rise in terms of the piercing of the veil in order to get into the IP. I want to let the gentleman to my left and the two gentlemen to my right go into more detail. They have examples of that I'll be honest with you, I'm not learned in, but I think it's imperative to know that we're seeing a buildup or a wave. And if by providing transparency, the same way that the defense is required to be transparent regarding their insurance policy, regarding their liability insurance, etc., well, why not have it on the other side? And be able to ensure that both sides have a very good understanding in terms of, in a sense, what's the playing field. And then once we understand the playing field, I think we have a better understanding, and the judge, most importantly, has a better understanding in terms of how he or she should rule in terms of how the proceedings should proceed.
Thank you.
You're welcome.
Vice Chair Reeves.
Chairman Jones, I'll put it to you, and if it's not familiar, feel free to other speakers take it up when you get there. But 1863 code, which is still on the books, and 13A or 1382A5 says that Champerty contracts are illegal in Georgia. They're against public policy. That's a contract in which a person with no previous interest in a lawsuit finances it with a view to sharing the disputed proceeds. How, if any, did that statute that's been on the books since the 1860s play into this bill?
So, Representative Reeves, I want to let the folks to my left and right speak to that. When I was going through my research, literally all of this, and my apologies, my head is killing me from being ill right now, but it speaks to the idea that there has been, for lack of a better phrase, a loosening of Champerty in terms of what has been occurring, I'll say, in the application of the law. So if it's okay with you, when it is their turn to speak, I'm going to ask them to be a little more specific than that, but my overarching answer is that there has been a loosening. I can't speak to why that has occurred, but hopefully one of the three can help me do that. Is that okay?
Absolutely.
Thank you, Representative Reeves.
Okay. And Representative Bruce?
Yes. Do you have any examples of the secrets that you're trying to protect? Do you have any examples of any of that being breached already?
Yeah, Representative Bruce, there is a Samsung case that I know has existed after they did an acquisition of a company and then effectively a third-party litigation. finance plaintiff went through there and tried to basically access certain intellectual property. But again, I'm going to go ahead and ask the 3 individuals who have come up with me, who are subject matter experts in this area, to provide greater detail into that case and then additional cases so that they would be answering your question in full.
Okay, and then the second question, if all this information is public, let's say China is putting up money for one versus India versus somewhere else, does the source of the funding impact the decisions that are going to be made about that case? I mean, because I guess what I'm saying is, if it's a friendly place, so to speak, providing the money, does that change it from an unfriendly place to supplying the money? Does it change the outcome of what we're trying to do?
Well, Representative Bruce, I appreciate the question because I can't speak for a judge, but I know this. I think by being transparent and disclosing that to the judge can take that into account. And I think the fact that, to your point, is it a foreign actor? Or is it a domestic actor that has proven to be a bad actor? Because I want to be clear, this isn't just foreign actors that could do this. This could be a domestic actor. But I think being transparent and disclosing to the judge allows that judge to be able to make, call it, a more educated, more informed decision on whether or not they're going to allow certain discovery, if they're going to allow certain access to certain discovery, et cetera. But again, I can't speak for a judge, but I'll let my 3 colleagues to also answer that question if that's okay with you.
That's fine.
Okay,
And one real quick last question. Is there anything in the books now that prevents a judge from telling both sides of the argument to disclose who's funding it? Is there something now that says that the judge can't ask that question?
Sorry, that's my medicine. Hold on. My understanding is that a judge cannot compel that type of disclosure. But again, can I leave that for my 3 colleagues?
Okay.
Thank you.
Okay, and Chairman Smith.
Thank you, Mr. Chairman. To my good friend, Chairman Jones, sorry I was a little late, but didn't want to miss a great presentation from the Pride of the University of Florida here today.
You didn't have to do that.
Well, Mr. Chairman, my father-in-law and brother-in-law, they both graduated from that school down there. So anyways, Chairman Jones, just wanted to ask, you mentioned Lockheed being concerned about this.
I'm sorry.
Is Lockheed Martin concerned about this?
I believe Lockheed Martin would have a concern in terms of their trade secrets, yes.
Is Andrew Dill here today? Because he's their lobbyist, and usually when it concerns Lockheed Martin, he's the front man on it here in the state. So I was a little confused if this was the issue for the largest defense contractor in the world, and we're down here in little old state of Georgia concerned with it. I kind of thought that Andrew Dill would be here. He's a good friend of mine, and I thought I'd have got a message from him if this was going to help them. So I just a little confused as to why he wouldn't be here today.
Well, I think there's a couple things. I can't speak for him, but what I could do is give you, first and foremost, because of my illness, and I'm trying not to get anyone sick, we weren't 100% sure that this bill was going to be heard today. I think the second thing is I think you're going to hear from a series of different people on this. I think the list is long. We're going to be here for a while listening to testimony. I believe part of that is a letter from Lockheed, but again, I'll let that happen within public record if that's okay with you.
Yes, sir. Thank you, Mr. Chairman.
Thank you, Mr. Chairman.
All right, now you may introduce your cohorts with you there.
Mr. Chairman, members of the committee, I'm Nathan Morris. I'm the Senior Vice President of Legal Reform Advocacy with the U.S. Chamber of Commerce, the Institute for Legal Reform. Do you want to do everyone first, or would you like me to?
Yeah, let's just go through the names. And
Good afternoon. I am Michael Gooden. I am here on behalf of Georgians for Lawsuit Reform as a board member of Georgians for Lawsuit Reform. I work for a large commercial insurer that has a presence here in the state of Georgia.
okay, thank you. And you got that mic.
Good afternoon, Mr. Chairman, members of the committee. My name is Mark Behrens. I'm a partner with the law firm of Shook, Hardy & Bacon, and I'm here today as a subject matter expert for the Georgia Chamber.
Okay. All right. Gentlemen, proceed however you want to do it.
I'll go first, and I'll go a bit off script because I think the questions that were asked were very good ones. Representative Kelly asked about the age of TPLF as a product, and Representative Jones is correct. About 30 years, primarily started in Australia, moved to Europe, came here, but for a very long time was an esoteric and rare product. It grew rapidly, especially during the pandemic, and it's now a $13.5 billion industry, assets under management. The industry itself projects it will triple in size in the next 10 years. So this is a problem with kind of a hockey stick effect. So what would have happened 20 years ago is not what we're looking at 4, 5, 6 years from now in terms of investability and the amount of money involved and how actors may behave in the legal system. The other question you asked was about foreign influence. Now, I don't have a security clearance, but don't listen to me about this. Listen to Senator Marco Rubio, who's the vice chair of the Senate Select Committee on Intelligence. He wrote a letter to every Florida judge and said, you should require disclosure of foreign funding. It's a risk to America. Your own AG, with 12 other AGs, wrote a letter last December of 2022 to Merrick Garland, the U.S. AG, and said, I'm very concerned about foreign influence on the U.S. legal system. What are you doing about this? DOJ, thankfully, has responded because their Foreign Agents Registration Act division has announced that foreign funding is now an enforcement priority because they're concerned about the prevalence of foreign funding in America. The U.S. House Select Committee on China produced a report last year where they said, we're worried about foreign funding and we would like to see disclosure and limits on foreign funding. So people with clearances who understand how geopolitical actors are affecting America have expressed across the aisle concern about foreign funding. It is a very serious issue. So I appreciate the question. I hope that don't listen to me, listen to them. They know before more than I do about what risks America faces. Representative Bruce asked great questions about the prevalence of funding and how it's affecting IP cases. The Samsung case Representative Jones mentioned was financed by China. So there is a Chinese entity called Purplevine out of Shenzhen that was funding U.S. patent cases. There are some in Delaware. We've now learned there are some in Texas. Now, when a reporter, and don't ask me, ask other people, sometimes they know better than me, a reporter reached out to Purplevine and asked, what's up here? What are you doing? Why are you funding these cases? The response came back from a person with an @tcl.com email address. TCL is a partially state-owned enterprise that competes with Samsung in the consumer electronics arena. I find that concerning. Now, why do we know this? We know this because one judge in Delaware requires disclosure in his court only of litigation finance agreements. So in his court, he's found Chinese money, which then led to discovery of Chinese money in Texas cases. He also has moved to send for bar referral attorneys who failed to disclose French sovereign wealth fund money. So that's the French government invested in U.S. suits. So we know there's foreign money, and we know that it's affecting intellectual property and American businesses. So these are all very serious concerns. Now, when this judge entered this order in Delaware and said, tell me if you're funded, what did funders do? Did they comply? No. Many of them withdrew their cases. Cases just disappeared. Some of them fought him, and they took him up to the circuit court and said he doesn't have the authority to do this. So one of the important things about this bill is that it will concretely ensure that things are disclosed. There won't be this rigmarole, does the judge have the authority or not? It's going to be out there. It's going to make it clear who's funded, who's not, and that's healthy for the system. I want to respect my colleagues' time. I would like to touch on quickly what the bill will do and won't do. As Representative Jones said, it will require disclosure of funding. Importantly, it's not just to businesses and litigants. It's to the plaintiffs themselves. It's pretty common, my colleagues will talk about this, for firms to take out portfolio loans where they've taken out very large loans, which repayment of is contingent on their case outcomes, and their clients don't know. A prominent example of that is Boeing's Lion Air crash cases. They were prosecuted by a prominent California attorney, Tom Girardi. Some of you may know him from Aaron Brockovich. He was involved in those cases. Girardi's firm went bankrupt. It turned out he'd actually taken out a very large loan from New York hedge funds, which was contingent on his cases. Those funds got paid back. A bankruptcy trustee moved to claw the funds back unsuccessfully. Many of his clients got nothing, and the clients didn't know the funding was there. So this bill makes sure that clients know if their firms are funded so they can protect themselves, maybe get different lawyers, maybe be in a better position to figure out how that relationship should work. But there are other really important consumer protections in here as well. On 60 Minutes, a few months ago, the CEO of the largest U.S. traded funder, appeared and was interviewed by Leslie Stahl. I'd note that funder is, their largest shareholder is Saudi, and their single largest investor is an undisclosed sovereign wealth fund. So this is it's an American outfit, but with a lot of foreign connections. He was interviewed by Leslie Stahl, and he said, well, in some cases, we make more than the plaintiff. Because she pushed him on that point. How much do you make an average case? usually invests no less than $5 million, usually doubles his money, wins 90% of the time, sometimes makes more than the plaintiff. So what Representative Jones' bill does is ensures the plaintiff makes most of the money. In any litigation that's funded, the plaintiff has to get 50% plus $1. I think that's fair. It ensures the plaintiff gets the most money. It also ensures the plaintiff is in charge of his own case, which right now funders maintain we don't have control, but there are public examples of funders taking control. Burford comes up a lot, in part because they're publicly traded and more is known about them, but they were involved in a matter involving Cisco, a large food distributor, and its antitrust claims over meat pricing. Now, personally, I care that a company with foreign money is involved in suits about meat pricing because I buy meat. You may not. But at the end of the day, Cisco wanted to settle its cases. It had dozens of defendants. They had money on the table. They wanted to end the cases. And it turned out, even though Leslie Stahl was told by this man that he did not have control over litigation, he did. Burford blocked the settlements. And so there's ongoing litigation about whether Burford can substitute itself for the party it funded, take over those cases and prosecute them against dozens of small and medium-sized companies. So this is an example where Goliath got funded and is using that as a cudgel to beat David, and now someone else is taking the cases and prosecuting against these small and medium-sized firms that really want the litigation to end. So they're stuck in a cage match with a financier that they didn't even know was there because it was non-transparent. So Representative Jones's bill is a very good piece of public policy. It's designed to address an actual and serious problem, and it would do so in ways that don't disadvantage plaintiffs or firms that want to use the product. It's still available. It's just out in the open, and with reasonable limitations that ensure that the system, our legal system, which is one of our crown jewels as America, is well protected. So with that, I'm happy to answer questions or cede the floor to my colleagues.
Question from you. All right. Representative Reeves.
My question is the bill mutual? Does it apply to defendants and counterclaimants as well as just plaintiffs?
Yes, it is not plaintiff specific. It's really criminal language. If you have funding that falls in the definition of litigation finance, if you're defending something and you have a counterclaim and you finance that claim, that's fully disclosed to SIN.
Okay. Have you studied how frequently defendants and insurance companies borrow money relating to litigation?
It's certainly more common for plaintiffs to take out this product. I'm not going to dispute that notion, but on the defense side, insurance is heavily regulated. So you're looking at an unregulated product, which is not exclusively plaintiff side, versus insurance, which is on predominantly the defense side, heavily regulated. But defendants do use litigation financing in some aspects. They'll often use it as a risk management tool.
Do you know in Georgia whether there are any provisions that do regulate that question of whether insurance companies are borrowing money relating to litigation?
To the best of my knowledge, there's a complex regulatory scheme for insurance. I defer to others on exactly how Georgia's insurance regulation works, but there's usually looks into capital and capitalization.
And are you going to testify?
I am.
Okay, I'll save for that. Thanks.
All right. Representative Kelly.
I think mine's an insurance-related question too, so I'll wait.
All right. All right. Go ahead.
Thank you. And I'll preface by saying my background is as a litigator and a trial attorney. I'm not an expert on insurance regulatory issues, but I will certainly do my best, to the best of my ability, to answer any questions I can. But I do want to say that at the outset because I know you have some. I want to start off by touching on something that Mr. Morris mentioned, which is portfolio funding, and to tie into some of the questions that have come from across the room. The fact of the matter is that litigation funding right now operates in near total secrecy. Only a handful of courts across the country require disclosure. And so we know very little about the industry. Most of what we know collectively as the general public comes from circumstances where a plaintiff sues a funder, or a funder sues a plaintiff, or a plaintiff's attorney sues a funder, or a plaintiff sues their attorney about funding. It's when something goes terribly wrong, we find out about it, and those issues make the headlines with relative frequency. But in 46 states and the vast majority of federal courts, litigation funding is not disclosed. So this is happening in a way that, unfortunately, we're not going to be able to get the answers to some of these questions. And that is the benefit of disclosure. It was, I think, Justice Brandeis, before he was a justice, that said sunlight is the best disinfectant. The portfolio funding phenomenon, and I'll go a little deeper into this, has an incentive. It builds an incentive to favor quantity over quality when it comes to lawsuits. And the reason that is because a firm can take a bundle of suits, some meritorious, maybe some not so meritorious, and immediately monetize those suits. And then those suits may be packaged by the funder and resold as a security. And they're immediately monetized by the funder. And so the need to have more cases becomes greater than the need to have good cases. And that can even lead to examples, and we've seen these, of outright frivolous or fraudulent cases, because the firms who are signing up these clients can turn around and sell the cases to funders. I don't know if any of you recall the Deepwater Horizon oil spill, and it was discovered in that litigation that there were tens of thousands of fake claims. And with increasing frequency in these mass tort and multi-district litigations, we find fraudulent and fake claims in the thousands. And the reason that is because those fake claims are being monetized and sold as part of a portfolio. The funding allows or gives an incentive to sign up the fraudulent and fake claims. And one of the key provisions of this bill, I believe, is that the disclosure will act as a disinfectant. When we can all have knowledge of what's going on, it will discourage bad actors. But the other benefit of this bill, there's many attorneys, many plaintiffs who use funding in a responsible way, and this bill doesn't eliminate that at all. It places reasonable regulations around funding, and it requires disclosure, but in no way does it prohibit funding or eliminate access to funding for a plaintiff who needs it. So it strikes a fair balance between the needs of protecting the integrity of our judicial system while still allowing access to funding for plaintiffs and for plaintiffs' attorneys. I also wanted to address the Champerty question I had in my notes. Champerty is an old doctrine that goes back even to English law, and I won't profess to be an expert in that sort of archaic language, but I do know that courts around the country have increasingly found that these Champerty provisions don't bar litigation funding. And while I don't have the site in front of me, that is the case in Georgia as well. And that's why litigation funding is able to operate across the country. So Champerty is by most courts has been considered to be an outdated doctrine that doesn't prohibit this litigation funding. So, and to address directly your question, an individual court may take the step of requiring disclosure of litigation funding, and that's exactly what happened in the Court of Delaware. Every court that's done that has found that litigation funding is occurring and sometimes found abuses, but there are always challenges to the court's authority to do so. Another really interesting example was the NFL concussion settlement, which some of you may have heard of. The NFL settled a class action from its former players that alleged that the NFL knew that football was a dangerous sport and could lead to dangerous head injuries, long-term damage, and didn't do enough to protect its players. Ultimately, that case was settled with an uncapped settlement fund that rewarded awards based on a scale that related to the severity of your injury. So if you had CTE, Alzheimer's, dementia, you would get a certain amount of money. And as soon as that settlement fund was announced, funders began to swoop in. They were making loans to the individual players, but they were also making loans to the attorneys who were representing the players, portfolio loans. So these attorneys would bundle up their cases and sell the portfolio to litigation funders. Eventually, the judge in that case got wind of what was going on, and the interest rates were usurious. They were so high that many of the players were going to be left with nothing. And the judge tried to bar those loans. Ultimately, that went up to the Third Circuit. The Third Circuit found that the court had overstepped its authority under the circumstances. And, some of the tragic outcomes there were that many of the players did end up with nothing. And the other interesting fact was that many of the attorneys who had steered their plaintiffs towards funders were also taking loans from those very same funders. So it was a concerning situation all the way around, and I think it's a case that really highlighted to me the need to have some disclosure on the front end, because now we're left with a situation where the disclosure only comes when something has gone wrong, and we'd really like to avoid that. And I'd be happy to take any questions. Thank you.
Chairman Smith. All right. Vice Chair Reeves.
A couple of questions. You mentioned you represented an insurance company, or that was mentioned in introducing you. Which one is it?
I work for Zurich, North America.
Zurich, okay. And then you mentioned litigation funding is not champerty, it's not illegal, it's legal. But that's litigation funding that's a loan, right?
Litigation funding is a non-recourse, typically defined as a non-recourse loan where repayment is contingent upon the outcome of the case. So it is not a traditional loan in the sense that if you borrow the money, you may not have to repay it. If you are unsuccessful in your case, you don't have to. So it's not.
Right. But China loaning money on a case to get intellectual property or a percentage of the claim, that's not litigation funding. I mean, that would be champerty, right?
If the loan was not contingent on the outcome of the case and it was a traditional loan, I don't think it would, and again, I'm not an expert on the law of champerty, but I don't think it would fall under the law of champerty, and I don't think it would fall under this bill under the definition of.
What I understand about champerty is you're not supposed to share in the proceeds of the case. You can loan money, that's litigation funding, but if you were, buying a part of the claim and you're a third party, that's what champerty is. And so this argument about China loaning money for litigation so that they could get their hands on intellectual property or a percentage of a large amount of proceeds, to me that would be champerty. That's not a litigation loan that is legal. That's more of, champerty, right?
I understand I'm sorry, I think I misunderstood your question. So if the loan was to take an interest in the case, but
Right.
was also not a non-recourse loan, then yes.
Not just non-recourse, but this whole notion that China is trying to gain a competitive advantage over businesses in America by getting intellectual property in litigation or, getting a large share of a company or large amount of proceeds. That would be champerty, whereas litigation funding is you have a loan, it may or may not be contingent, but it's a loan and that's it. If that loan's paid, you're done, right?
Go ahead.
Sure. So with the litigation funding, it is a loan, but it is no repayment is required. And I may be misunderstanding your question. I apologize if I am. It's contingent on the outcome of the case, non-recourse. The loan to access, I think the concern about accessing trade secrets that was expressed, it's not written into the contract. The concern is that when you insert yourself into the litigation, you're gaining access to everything that takes place in the litigation. So the loan may not specifically state, I'm going to obtain trade secrets, if that's
Sure.
if I understand the question.
One final line of question: the CTE issue. Representative Dewey McClain's a CTE and retired NFL athlete, advocate. A lot of those retirees live in my area. Is CTE, is that a live issue or is that concluded? Is there fraud on CTE victims, or is that done? Is that still going on, or is that
Is the NFL concussion? Well,
Right.
The administration of the settlement is still ongoing, if I understand your question.
okay? So you think action's needed here in Georgia to protect the CTE NFL retirees based on litigation funding issues?
No, I was using that as an example of some of the problems that can arise. That case is in federal court, and so I don't think this bill would directly affect that, but I think it's a good exemplar of some of the problems that can arise when litigation funding is injected into the civil justice system.
Thank you.
Mr. Chair, if I could address Representative Reeves' question, just from a practical standpoint, I'll let all of you legalize it. If I'm a bad actor, whether or not I'm China, Iraq, Iran, or just a domestic bad actor, the fact of the matter is it's irrelevant to me if I get paid back. To me, fine, it's a non-recourse loan. I'm putting $1 million in, but what matters to me is getting access to things that, frankly, I wouldn't normally get access to, including trade secrets. Win, lose, draw, I get paid back or not, I consider that a sunk cost. The $1 million was an easy sunk cost in order to gain access to companies' IP that may have cost them millions, if not billions, of US dollars. And suddenly, instead of having a 10-year, I'll say, competitive advantage on my competition, I now have a 10-minute advantage because now they've got access to it. They could almost, if you think about it, the bad actor could just walk away, not really caring what really occurs, because of the fact that the return on their investment, notwithstanding it's not supposed to be an equity type, investment, it's supposed to be a non-recourse loan. The return on the investment is literally, it's I don't even know if it's calculable. It nears infinity if in fact that was to occur. So, but I'll let you all kind of argue the legal principles, if that's okay.
So were they getting their hands on the intellectual property in discovery then? Not, I mean, before judgment? Is that the problem?
Yes.
Okay.
Right. So this is like, I'll say during the game, for lack of a better phrase. And again, I'm using an NFL metaphor since you guys started with it. Okay. All right.
And your bill accounts for that.
Yes, that if in the bill, right, you're disclosing to the judge, so the judge then makes the determination and, well, I would assume takes into account who are, I'll say, the actors within this play to determine how the play should play out in terms of who should get access, who should be barred from access. Because in my mind, and again, Judge, you are a judge, or Chair, pardon me, you were a judge, you have the ability to say that Representative Reeves can have access, but not maybe the individuals who had who provided the funding to Representative Reeves. So Representative Reeves, as the attorney, should get access to that discovery, but Representative Reeves needs to have a disclosure back to you that no, there would be no one else within, I'll say, his side of the litigation that's going to get access. And again, that would be something that a judge would be able to do.
And it would also help the other side defend themselves if they knew that that was going on.
Correct.
So, all right. Chairman Smith?
Thank you, Chairman Gunner. Question for the gentleman there of the learned profession beside you, Chairman Jones. You mentioned that somebody had failed to put provisions within the contract to protect this sort of information. I think I'd heard you make that comment that somebody didn't put it within the contract to protect the information such as this and made this subject to disclosure.
I think we were. I think I remember what you're referencing when we were discussing whether collecting trade secrets would make it champertus, and I was trying to reference the fact I think that was more eloquently stated that really the obtaining of the trade secrets occurs in discovery. So they're not entering into a loan agreement with the repayment being I'm going to obtain trade secrets. It's more that they're inserting themselves into a litigation and using the litigation as an opportunity, regardless of what the loan agreement says. And I think I was misunderstanding the question a little bit, but that's the point I was trying to make. It's not something that they're contracting to get trade secrets, but they're using litigation as a vehicle to potentially obtain this information.
Okay.
But some bad actors actually use it to get the information.
Cool.
Yeah. Okay. All right.
Mr. Chairman.
If you're done.
Yes.
Okay.
Thank you.
Go ahead.
I'm sorry, I want to be respectful to the gentleman in the corner to make sure he can.
Okay,
see
I'm
and
sorry,
hear
you're going to
me.
have to get
If I
right
reach
in
to
that
the
mic.
You won't be able to see me, but can you hear me now?
Yes.
All right. So I want to address a few of the points and amplify some of the things that have been said today. So why here, why now? Goes to the gentleman's question. Third-party litigation funding, we call it TPLF. It is new in the sense of the scale that it's occurring today and the impact as lawyers you should be concerned about. And as a former judge, I understand. Because at this 60 Minutes program that we talked about that aired last December, there was a professor, Leslie Stahl interviewed a professor named Maya Steinitz, who's a neutral in this. She's not defense-oriented. She's not a plaintiff's attorney. She studies this for a living. And she said, TPLF is reshaping every aspect of the litigation process. Which cases get brought, how long they're pursued, and when they're settled. But all of this is happening without transparency. So we have one of the three branches of government that is quietly being transformed. That should be of a concern to the Judiciary Committee about how our civil system is being changed in the dark. It's happening without our knowledge in many cases. Now, what are some of the concerns about that this is happening? One is that third-party litigation funding can raise very serious ethical issues. One goes to the champerty aspect that you discussed, Representative, to the extent that champerty is still a valid doctrine in Georgia. And it's eroding in many states, which is why this is happening. But I'm not an expert on the intricacies of champerty law in Georgia. But if, in fact, these types of plans would be considered champertist, that's something that the court needs to know. Otherwise, there are violations going on in Georgia without the court's knowledge and without the defendant's knowledge. That's something that the courts have an interest in policing, not just defendants or insurers. The other is that all of us that are members of the bar have a duty to exercise independent judgment and zealously represent our client. That means that we have to put our client's interest first. And when you have a funder that's involved, that gets clouded, right? What's the golden rule? The person with the gold rules. Here the gold is the funder. Are they ruling, or is the consumer, the client, deciding the case? We know from the Cisco example that the wealthy funder in that case was deciding. There are times when a consumer may want to settle because they need money to pay family expenses, or they don't want to run the risk of going to trial and losing and getting nothing. There are many times where a consumer says, I don't want to go for the nuclear verdict. I want to take care of my family, especially if I do work in a lot of asbestos cases, for example, where people with mesothelioma maybe have 18 months to live. Okay? The most important thing for them is to know that when they're gone, their family is going to be taken care of. They want those settlements. But when you have a funder at play, the funder may say, no, I'm going to move to block that settlement because I don't care about the injured person. Their only care is the return on investment. And that puts the lawyer in a bind, and it could be adverse to the interest of the consumer. So that's a second ethical concern. And we have, from the Cisco example, a concrete example where this has happened. Even though the CEO of that company told Leslie Stahl on 60 Minutes, we don't do that. We just put up the money and the lawyers control the shots. We know that that's not true from an opinion by a federal judge just last month in Minnesota, who said Cisco, a large food distributor and a direct plaintiff in these cases, wanted to settle. Burford, its funder, did not favor, and Burford refused to permit the settlements. So what we're talking about is happening. This is a new opinion from a federal judge just about a month ago. The other concern that we've talked about, and where this bill really focuses in, is the concern that foreign adversaries could weaponize our civil justice system. Now, there's a couple of ways that could be done. One is through going to actually get the trade secrets, the intellectual property, the proprietary information. And we know that that is a threat that needs to be taken seriously. Nathan mentioned a number of examples at the federal level where policymakers that have security clearances are concerned and are taking action about this. But in November, Bloomberg reported that a Chinese firm is financing 4 intellectual property lawsuits in the U.S. courts. Okay, so we know China's behind some of these intellectual property cases. I don't want to overstate how much this is happening, but we know it is happening. And the disclosure of a funder tied to China, this is from a former acting director of the U.S. Patent and Trademark Office, who knows policy. He said that a funder tied to China is our worst fears confirmed. And he added, anything China does is concerning, because nothing over there is really independent. Now, they could be funding lawsuits to get access to this, or they could just be doing it to make money, right? They're investors, they want to make money, but by putting money into our system to fuel some of these lawsuits, speculative lawsuits, to make cases more costly and more difficult to settle, they are destabilizing Georgia businesses and making Georgia businesses less competitive. So apart from the trade secret issue, there is a competitiveness issue where our adversaries can weaponize our civil justice system. And again, the bill deals with that in a very modest way, which is to simply require disclosure. And then lastly, Nathan gave an example that this bill is pro-consumer, because there are cases today where lawyers are taking out loans to fund their cases without the consumer's knowledge. And I'll give you just one other example that was reported in Bloomberg a month ago, very recent, of a lawsuit that was filed in Philadelphia by a plaintiff who had an occupational injury case. He went to a lawyer. The lawyer got a settlement for $475,000. This gentleman was probably happy, at least to know he would be protected and relief was coming, until he got the itemized bill from his lawyer, which showed that the lawyer, without his knowledge, had taken out an $81,000 loan to cover the lawsuits, which with interest compounding daily came to $137,000. So this consumer found out after the fact that roughly a third of his money is going to an entity that he never knew was involved in the case. This bill will protect consumers by making those types of arrangements be disclosed to them. And with that, I'd be happy to answer any questions that the committee may have.
All right, Representative Bruce.
I got a couple of questions, if I could. If me as a client of yours, don't I have a right to believe that whatever's happening between you and I is between you and I, and not anybody else? Is that?
It's a great point you're going to, because absolutely you should. But those communications that you may think are just between you and your attorney, in these settings, may be shared with that funder, because the funder does due diligence, right? The funder doesn't just, they're business people. They're not just going to make a loan to somebody without trying to find out how much is the risk and what's the reward.
Okay, but let me finish my question.
Please.
If I have that expectation that it's between the two of us, and you as the attorney choose to share it with someone else because they're funding you, are you now violating the law by doing that, or violating the relationship between you and I as I guess it becomes an ethical question as to whether the lawyer is doing something that they're not supposed to be doing.
A very astute question, and absolutely right. And that goes again to the ethical tensions that these play, because that attorney is bound to maintain confidence with the client, and yet often that information is shared with the funders as part of their due diligence.
Okay, well, I'm just trying to make sure we're solving the correct problem.
Yeah.
To me, what I just heard is that the problem is that you have lawyers that are not doing what they're supposed to do.
Well, what they do is the funding agreements almost all now, because there have been some discovery where these came out, the funders now all require that the information is under, that it's protected from disclosure. So they try to extend the attorney-client privilege to them. The attorney-client privilege certainly doesn't extend to a funder, but typically what they'll argue is it is attorney work product, and therefore it's protected. So it's maintained from discoverability through a different avenue, if I put it that way.
Thank you.
Okay. Vice Chair Reeves.
Thank you, Chairman Gunner. I learned from Roger Lane, who is a member of this committee, I believe, with Representatives Bruce and Oliver. He's now a judge. He did asbestos and mesothelioma. That Georgia's got an above-average number of those cases from shipyards and the coast and all that. You mentioned mesothelioma. Have there been any instances of that abuse here in Georgia?
Of abuse in terms of lawyers that have taken third-party litigation funding? It's a good question. I can't answer that when this is all kept in the dark. You know, the disclosure is not happening today. So to ask me how many times are firms being funded in Georgia and what's the level of funding is asking me to bring you a bucket of steam, because the information is hidden. That's why we need the bill. But, you know, it occurred to me I wanted to go back to a comment you had made about insurance. What the bill would do is make this a two-way street, because as you know, under Georgia's current code, insurance agreements are discoverable. So the plaintiff today, let's say it's an auto accident case, the plaintiff can ask the defendant, give me a copy of your insurance agreements. So they can get the access to the amount on the defendant's side to pay for the lawsuit today. What this bill would do is level the playing field by having the same sort of access to the funding source on the plaintiff's side.
So no mesothelioma abuse cases you know of in Georgia?
I don't know of any specific cases where plaintiff firms have taken that
Okay.
here.
Have y'all engaged with the State Bar of Georgia to see if they have any tools already at their disposal to regulate abuses of litigation funding?
I have not been involved in that, no.
And federal or state court in Georgia, can you identify any instances of abuses of litigation settlement funding in Georgia?
Again, Representative, I can't because this is all done in secret. I think if this bill passed, it would be very enlightening because you would find out that this is certainly happening. It's happening on a national scale. As Nathan said, $13.5 billion is flowing into funding lawsuits today. So it's absolutely certain in a big state like Georgia with a lot of businesses that litigation funding is being used against Georgia businesses, but without disclosure, I couldn't quantify the scale of that activity.
If I may on that point, it's often instructive to look at what the funders say themselves. And so the funders advertise how they know the cases, how they study cases, how they determine what to invest in. And one prominent funder has a piece of software they call Diamond Mine, and they say that roughly 50% of the 4 diamond cases that are highly investable are in states. So if you look at their own marketing materials, they intend to invest in states, and I am assured here today, as I am that the sun will rise tomorrow, that they have money here. I also don't want to speak for Georgia companies, but I would encourage you to talk to some large employers here. I can assure you they've had experiences with funding both in Georgia courts and outside of Georgia that will rattle you.
All right. Oh, I got another question. Representative Holcomb.
Thank you, Mr. Chairman. Not sure if any other members of the committee have a background in national security. I do, and had a top secret SCI clearance. And of the things that worry me at night, litigation isn't really one of them in terms of our national security, but maybe I'm wrong on that. So I'm trying to figure this out, and I'm a litigator, and most of what I've done is on the defense side. I used to work at one of the big law firms in town, and I have my firm now, and I'm not sure that I understand how this impacts the flow of cases and makes them not settle, because isn't the exposure, like whatever the overall risk is? So why is it preventing cases from being settled? I'm not sure that I understand that.
It's helpful to look at what they say. Allison Chalk at Omni Bridgeway, a prominent funder, told the Wall Street Journal a couple years ago, we make cases longer and more expensive to settle. So they acknowledge that's the effect they have on the system.
But why? I mean,
Well, an example might be...
because they want to get paid, right? On the plaintiff side,
Well,
don't they want to get paid?
Let's pick the Cisco example. Cisco wanted to settle with its protein suppliers. They have an interest, an ongoing business relationship, right? They don't want to put their suppliers out of business, and they got to continue to work with them. So they came to a settlement with their suppliers on terms that they thought were mutually agreeable. It wasn't till then the funder came in and said, no, we expect a higher return on our investment. So we're going to block that settlement until we get more money. So that's an example where that case would have settled had it not been for a funder's participation. And the fact the judge in this Minnesota case said that. The judge said, I can't find it here. I don't want to wait your turn. But the judge came in and said that the impact of having a funder in the case was significant in terms of expanding the litigation, making it sort of take on a whole new life.
Okay. Is it not possible for the defense to just say, pound sand, I'll take the case to trial and beat you?
That's certainly possible. But one of the concerns about funding, as Mr. Gooden said, is volume matters. As a litigator, you probably realize that leverage is an important aspect of litigation, and claim quality is not always the determining factor. A high volume of low-quality claims can create incredible leverage. So I've seen, for example, a pitch deck from a law firm that wanted to raise capital to file bulk arbitration claims. And the deck flatly says, it doesn't matter if the claims are of quality or not. It matters how many we have. If they're losers, they're worth about 25%, but you'll still make a 500% return. If they're good claims in arbitration, and this bill does cover arbitration, covers any dispute resolution. We think we can get an internal rate of return pushing 1,800% by just digitally advertising for and filing bulk claims. So it's an interesting business because it's not always just about is the claim good. It's about how can we monetize it.
Can you tell me a little bit more about the arbitrations? What sector of the economy or what was that focused on? Like I do securities, which is almost all in arbitration. So,
So
I'm familiar with it.
this particular pitch deck was made public as part of litigation that concerns Valve, a distributor of video game software.
Okay.
If I could, Mr. Chair.
Sure.
Again, from a practical standpoint, Representative Holcomb, again, as I learn more about this, it's a private equity play and it's a hedge fund play from a quantity versus quality point of view. I mean, if you know anything about the game theory that private equity firms do and hedge funds do, I get it from just a capital point of view and from a capitalistic point of view. Look, I love the capital system. But again, within our third branch of government, or I shouldn't maybe call it the third, they'll get upset equally. The judicial branch of government, the fact of the matter is that shouldn't be the playground by which we're effectively looking at 1,800% in terms of the IRRs. I get IRR, and God bless America. I hope you get a 1,500%, but not by perverting basically the litigation that is going on within our country. I think the second thing is the question that you asked them, and I know you asked them from a legal standpoint. I'll answer from a business owner standpoint regarding settlement and regarding taking it to jury.
Yeah.
It is shocking. We now, and I'm now speaking from personal experience, we have employees who literally resign and suddenly there's an EEOC complaint. And I'm like, an EEOC complaint? They resigned. And all of a sudden, there's, of course, certain things that are alleged. Of course, the government comes in, they do their research, and they find nothing, thank God. Many, many times I'm told, you have a majority-minority management team, so this holds no water. But yet, as soon as it's closed, what comes right after that closing? The lawsuit. We all know what they're going after. There's no merit behind it, but we know exactly what they're going after. They're going after our money. So I get a phone call from, our liability coverage. They tell me, hey, it's going to cost this to be able to defend 2 verdict, or you can probably just settle for X minus that. So unfortunately, just from a business standpoint, as a business owner, I sit there and I'm literally just gritting my teeth. Like, I cannot believe the injustice of this. I literally am going to have to, basically do a wire that this person has no merit, but rather I'm just feeling like I'm being shaken down. So what do? I don't take it to jury. Maybe I should one time just to prove a point. But at this point, I can't think of my shareholders from the fiduciary responsibilities I have to them as the board chair and effectively say, I'm going to go ahead and drop $500,000 on litigation instead of just paying out $75,000 to make this thing go away. It would make me feel better to drop the $500,000 to take it to verdict because I think I'd win. But at the end of the day, from a business perspective, I got to just drop the 75 or the $100,000, wire it and be done with it. And frankly, go have a glass of bourbon and then basically try and think about the next day. So
I like bourbon. Thank you.
me too.
Representative Bruce.
A question. When I interact with an attorney, I agree to pay X percent of whatever the outcome is with that attorney. So in terms of who's getting money in this conversation, I'm still getting a little confused because if I agree to give you a third or whatever it is, shouldn't any interaction that you have with someone other than me come out of the 1/3 that you're supposed to get? So that's why I'm confused
that does happen sometimes, but it also happens that it's charged as an expense, as in the Pennsylvania case that was alluded to earlier. So we've certainly seen cases where the plaintiff is charged the financing cost as an expense, as if you were charging for an expert or anything else. So it happens both ways. And what the bill does is it allows attorneys and funders to, amongst themselves, figure out how to structure the financing as long as the plaintiff gets most of the money at the end, which we think is a very reasonable approach. So it doesn't affect how attorneys charge contingent fees. It doesn't set a rate. It does nothing to affect the availability of funding, except that the funder and the lawyer need to figure out a way to make sure that no matter how they structure their deal, the plaintiff leaves with the most money at the end.
And I'm in agreement with that, but I guess what I'm still trying to get at is at the end of the day, I, as the client, agree to pay X, whatever that is, out of the result of this.
Yeah,
out of the
a
total
standard
result.
retention agreement is going to be contingency plus expenses. And so really whether the firm takes the funding and then pays it out of their contingency, which could be fee splitting, or it's charged as an expense, which would be
So the plus expense is the part we got to be concerned about.
And if I could add to this, that often plaintiffs are unsophisticated parties. And if they receive the accounting at the end of the case from their attorney and it has an expense on a line item, as the Pennsylvania case, they may not know, especially in a system where no disclosure of funding is required, they may not understand what they're looking at when they see that $1,500 of expenses, and they take their money and never ask the follow-up question of, what is this? Why am I paying this? They trust their attorney. The disclosure requirement would simply give them an avenue to know that this is what is happening, so that the contract could be enforced as it is written, and they're not unnecessarily paying those extra expenses. So that's really, again, the disclosure helps solve a lot of the abuses that maybe otherwise wouldn't come to light.
Okay. Chairman Smith?
Mr. Chairman, it's appropriate time. Just got a motion.
Okay, we've got a whole list of witnesses
I'll
here.
be patient, Mr. Chairman.
All right, thank you. All right, anything else, gentlemen?
Could I be excused to just go to the...
Oh, absolutely, yes. All right. Okay. Okay, I want to go. Dan? Do you want Jordan and Brandon to come up as well?
They're on another bill.
Okay. All right, great. Thank you. All right.
Thank you, Mr. Chairman. I'm Dan Snipes.
You want to get up in that mic.
After Mr. Jones was here, I don't know if I want
Well,
to get too close.
sorry about that.
I can sanitize it.
I'll speak up. How about that?
Yeah, that'll work.
How about I'll speak up?
All right.
I'm Dan Snipes. I'm an attorney from Statesboro, Georgia, and I represent the Georgia Trial Lawyers Association. We covered a lot of ground just there, so I'm going to try to hit some high points and talk about some big picture things. Litigation funding is a big area, and it probably has exploded. And what we're talking about is really non-traditional litigation funding. Law firms can have lines of credit at Synovus or Truist or wherever, and they can use that to fund their firm and fund expenses in cases. If an individual wants to bring a case against a manufacturer of a drug or an automobile manufacturer, those are very expensive, very time-consuming cases. Individual plaintiffs who've been injured don't have access to that kind of money, and lawyers, by and large, do not have access all the time to the hundreds of thousands, if not millions of dollars it can take to bring the first case that says a product is defective, whether it's a drug or whether it's an automobile product or any other type of product. Non-traditional funding is what we're talking about. Places where you can get different types of loans for non-traditional funding. But it's just not an area of lending that's limited to litigation. There are numerous companies in Atlanta that do non-traditional funding for developers. And there's no law that says that a developer who's developing a neighborhood and building houses has to disclose where they get their money from. So houses in the subdivision could have a premium attached to their price because of the type of non-traditional lending that they have. Doctors who open surgery centers, if they have to go purchase large, expensive equipment, can turn to non-traditional funding to finance surgery centers, MRI machines, whatever else, whatever equipment they need. And those facilities are not required to disclose the type of funding they have, even if their services may cost more because of the type of lending they have. I'm not aware of any other American-owned business where we ask the businesses to disclose where do you get funding to do your operations. All right? So what is this really about then? Because we're getting into an area where we're clearly trying to say we want there to be certain types of disclosures. If this was about protecting access to trade secrets, we'd be talking about the scope of discovery under 9/11/26. We'd be talking about protective orders. There's already mechanisms in Georgia law that say this is something that either is not discoverable, or if it is discoverable, it can be disclosed pursuant to protective order, where a judge has the authority to say, these are the only people who get to see it. I mean, I have done products liability cases where myself, my paralegal, and only experts that I employ that I identify are the only people who have access to trade secrets. The court system in Georgia and really throughout the country has mechanism in place to deal with the protection of trade secrets. So that's not really what we're here about, because this bill doesn't address those areas of Georgia law. Trying to catch up a little bit. When we get to disclosure requirements as it relates to what the client, listen, the clients have an obligation to know what's going on with their cases. But in Georgia, the rules of professional conduct, as administered by the state bar, but the Georgia Supreme Court, first of all, has the exclusive power to regulate the practice of law in Georgia. And our rules of professional conduct deal with the relationship between the attorney and client and what the disclosures have to be. And yes, this is the type of information that an attorney should certainly disclose to their lawyer. And a lawyer is a fiduciary in Georgia and has an obligation already to put their interest above the financial, they have to put their client's financial interest above their own financial interest in all cases. And that's already the law in Georgia. And if lawyers are violating that rule, they're subject to being disbarred, and they're also subject to legal malpractice claims. So we've already got mechanisms in place to protect the client from a lawyer who's not honoring those obligations. But the cases they talked about, okay, the Cisco case is a patent, I think it was Cisco, was a patent case. Federal courts have exclusive jurisdiction on all patent and trademark cases. They talked about an antitrust case. Federal courts have exclusive jurisdiction on all antitrust cases. This law doesn't address any of the cases they talked to you about. They were federal cases, and most of them were cases where federal courts have exclusive jurisdiction. So this law is about one thing, and it's about when a lawyer takes on a case where he needs funding. They want it to be disclosed so the bargaining power between the parties is not equal. It's not about leveling the playing field. It's the exact opposite. It's making sure they know the pressure point for the lawyer and what kind of duress he may or may not be under. I mean, the thing that scares them are the really successful plaintiffs' lawyers who don't need funding. They self-fund. The self-funders, you never can put pressure on them. This is about how do we make the playing field uneven and have unequal bargaining power. And at the end of the day, that's all this is about. Georgia already has at least 3 statutes to deal with abusive litigation, because there was some talk about this is, you bring this and you aggregate cases and a bunch of them are frivolous. We deal with frivolous and abusive litigation in 915-14, 911-68, 51-780. Those are just top 3 that I got while I was listening, but we've already got ways to deal with bad claims in Georgia. I want to be brief and respectful of your time, so I'll answer any questions.
I have a question. Do any of the lenders that you're talking about, because the bill seems to address lenders that actually try to control the litigation and the discovery part of it. So, I mean, are these lenders that you're familiar with, are they doing that?
No, sir. Not to my. I'm not aware. First of all, I'm not aware of there ever having been a problem in Georgia related to this. I think, like I said, the issues they brought were other states and primarily federal cases brought in other states. But I'm not aware of where the what's it like with the non-recourse. Because a friend of mine does he does non-traditional development loans for a company based in Atlanta, that's Austin, Texas, and Ponte Vedra, Florida. Okay, and he's not telling the developers when to sell the house, but he's going out and checking on the houses. And I think what happens in these cases is they're not telling lawyers when to settle the case and not to settle the case. They're asking for status updates. Where are you in the case?
Okay, so what is the harm in Georgia to disclose that there's somebody financing the litigation?
I don't think there's any harm in disclosing it to the client. I think when you disclose it to the opposing party, then you have an unequal bargaining position where the other side knows, okay, this is the lending agreement. If we wait an additional 6 months, Dan Snipes is going to have to pay an additional X amount, and he's going to pay an additional X amount after this period of time. And it creates an incentive where they know where my pressure points are, and it's an unequal bargaining position. And it's completely contrary to the existence of insurance to pay the amount on the other side. is completely, that's not a fair comparison. The reason it's fair to require an insurance company to say this is the amount of our policy is if I want to make a demand within your policy limits, if I want to try to settle the case, I have to know what the amount of the policy is. Okay, I have to know that in order to make a reasonable demand to settle it. If I got a client that's catastrophically injured and I don't know what the policy limits are, how do I make a policy limits demand? This is about unequal bargaining power.
Okay, all right. Representative Silcox.
Thank you so much for your testimony. I was curious, along those lines, just for the general consumer, if I were a plaintiff wanting to come, does the lawyer in their letter of engagement have to disclose if they're taking a loan?
Well, if we're talking about contingency fee contracts,
Right.
those have to be in writing. Now, I'm not aware, there's not a requirement that I'm aware of that says you have to disclose what type of lending you have in Georgia versus, at various points in time in the ebbs and flows of things, my firm's had a line of credit at Synovus. I've never had, but there's no requirement that I have to disclose my firm has a line of credit at Synovus. So likewise, there's no requirement, but I think within the disclosure to the client and being a fiduciary when you're sitting down with someone and you're talking about what the expense structure in the case is, and as a plaintiff's lawyer, I have an obligation to make sure my clients understand what expenses we're spending on a case and making sure they appreciate it. And that is an expense, whether it's a litigation funding expense or if I'm going to hire experts.
I guess I'm just referring
Yeah.
to the example they gave where
Yeah.
the client received the bill and it was, a lot, they received a lot less in the settlement than they thought they would, $475,000 because of $137 or whatever $1,000 of loan payment that they had to repay. So to me, that's material.
And I think Georgia's rule of professional conduct already require client communications that would cover that issue, and the lawyer will be subject to discipline for violating that rule of professional conduct.
So do you think that Chairman Gunner's question that the loan or knowing the amount of the loan, would that be like finding out for the other side the amount of the policy?
It's completely opposite, and I'll try to explain that again.
Okay.
Okay. The reason why this type of funding is important because it deals with how much pressure can we put on the other lawyer to try to coerce them into settling on our terms. Knowing the amount of insurance, if I represent someone who's catastrophically injured and I'm trying to make a policy limits demand, I'm trying to resolve the case, I have to know what the policy is, the amount of the policy, in order to make a policy limits demand. Or if you need to know what ballpark you're playing in order to try to represent your client and explain to them, Mr. Client, unfortunately, the person who injured you only has this amount of insurance, and we're settling for their amount of insurance.
Okay, thank you.
Yeah, but shouldn't the judge at least know that they're dealing with another advocate if it's somebody that's actually trying to control the litigation?
Well, that gets into if somebody's a real party in interest, but this bill doesn't prohibit a funder from having an interest in the case. It's about trying to. That's not what this bill does. I don't think a lender should have an interest in a case. I think kind of getting to what, maybe we need to revise the Champerty law to say lenders can't have an interest in the case. Maybe they can only be paid, some fixed amount, but they don't get a contingency basis in the case. Georgia already has a rule too that prohibits lawyers from sharing fees with non-lawyers. So I don't know how they get around that rule in Georgia. So it's hard. I don't know. We've already got a lot of rules that I think address a lot of the concerns.
I'm just thinking that the judge would really need to see the contract that they have just to know what he's dealing with.
Well, they originally talked about the judge needing to see the contract so he can appropriately put limits on discovery. And that's already there for protective orders. It's either discoverable because it's relevant or it's not discoverable because it's irrelevant. And then a judge can fashion an appropriate protective order given the concerns of the party disclosing a trade secret.
If he knows that he's got a third-party adversary out there.
Does it matter if that third-party adversary is Synovus on a line of credit or, a litigation funder?
If it's somebody just dealing in the money side of it,
Mm-hmm.
I don't think that's a big deal. But if it's somebody that's actually controlling the litigation and has international interest in it, then yeah.
If the lawyer's allowing a lender to control litigation, he's already breaching his fiduciary duty to his client.
Okay. All right. let's see, who was up? Chairman Smith.
Thank you, Mr. Chairman. Gentleman from Statesboro, Mr. Snipes. I was just wondering, I mean, in the criminal world, I have a lot of young people that find themselves on the other side of the law allegedly. And so a lot of times they can't afford to pay the legal bill a lot of times. So their parent may do that. But is this not necessarily in a simple term? Just because you're paying for it doesn't mean that you have to disclose to that person paying for it unless the client approves of it.
I think it does, and I would say, you know, having practiced law in Statesboro with a lot of young kids who got in trouble, particularly years ago when I had a little bit more time to do some of that work, you know, the lawyer's always got to be cognizant of who his client is. Mm-hmm. And even if mom and dad pay the bill, the student at Georgia Southern was still my client. And that was a person that I communicated with, and unless the student authorized me to, I didn't share information with the parents, even though they paid the bill, because they weren't the client. And similarly, they were the ones who had to make the decision about what was in the student's best interest when it came time to resolution of the case. And really, that kind of gets back to your point with insurance companies. Insurance companies pay for the lawyers who are defending the cases, but we don't know what rates they're paying. We don't know how they're paying them. Is it a contract basis? Is it hourly? The plaintiff's lawyers don't know all that stuff. The lawyer hired by the insurance company still has an obligation to look after their client and not the insurance company. That's their fiduciary duty. So I think there's a lot of other cases, though, where there's, you know, and that's every car wreck case just about. An insurance company is the one paying the defense lawyer. They're the ones who have an interest in the case financially, but they're not, you know, the lawyer's hired to represent the defendant, the client.
Okay. When I was a judge, I let lawyers talk too much, so I'm going to call on the author of the bill, Chairman Jones.
Mr. Snipes. No, I have a question for you, bud.
I thought we were
I'm not trying to
worries.
run you out. So
Yep. You keep referring to Synovus, right? That's a bank where you have a line of credit.
Actually, not currently, thankfully.
Okay. Well, let's assume for a moment that you did have a line of credit, or
Yes, sir.
in your example, wouldn't lines 39 through 42 basically say very expressly that an attorney's line of credit, which is the normal course of business, not be included as third-party litigation funding?
Yeah, I think, in answering the question, I wasn't trying to make the argument that this bill covers Synovus. I was just answering a question about there's different types of ways lawyers have that, but none of it's currently discoverable. None of it is.
Sure.
And just because a party uses non-traditional funding as opposed to traditional, still doesn't mean there's not pressure to repay somebody.
Right, but Apple uses a line of credit all the time, and they're sitting on $100 billion of cash on their balance sheet. How a business runs their business is a business, and that's what a law firm is. It's a business. Would you agree?
Certainly it's a business.
Yeah, so it's a business.
Certainly.
Then the second thing is, in terms of, forgive me, I think you called it Rule 2. My apologies, I don't know all the different rules, but Rule 2 regarding you can't share the fee, the success fee,
There's
the contingent fee.
There's already a rule in Georgia
Right.
that lawyers are not allowed
To share their
fees,
contingent fee.
To share any fees.
Fees, any
with
fees.
non-lawyers.
Sorry.
It's
Right.
not limited to
Right.
contingent fees. You just can't share fees with non-lawyers.
Right. So the disclosure to a plaintiff, letting them know that, hey, I'm going to go ahead and, me as the plaintiff attorney, I'm just going to let you know that I'm going to take down this, I'm going to call it non-traditional financing, and that's okay. A hedge fund is non-traditional financing. Okay, I'm not going to Synovus for a line of credit, but I'm just going to go get non-traditional funding. I'm going to go ahead and do that because I think you have a good case, and we're going to go ahead and, just so you know, I want to get 40% just because I get that and say it's a contingency case. The 60%, there's a good chance you're not going to get the 60%. There's a good chance that I got to repay this non-recourse loan and whatever that amount is, and then you go ahead and get the rest of that. Letting the plaintiff know that up front just seems to me to be just fair. I don't think it's dubious. I don't think it puts you at a non-advantaged position.
The Georgia rules of professional conduct already require a lawyer to make those kind of communications to his client.
Okay. So then having that inside of this statute, then we're just saying we both agree that that's a good thing to do.
that's the reason why we don't need that statute, because that obligation's already there. And what this statute does is change the bargaining power between the parties to the litigation.
Let's go ahead and hit the bargaining power. Where in the bill does it say that when this is disclosed that the defense is going to get the actual amount of the third-party litigation funding?
Well-
Can you point me to that line?
To have a disclosure, okay?
Yep.
And normally, when I'm involved in litigation, disclosures would require a production of documents.
Correct.
So there's going to be a request for the lending agreement. So based on the lending agreement,
Right,
I think most of the time, you would be able to determine
right.
where you are financially with the lender.
Well, I agree you could surmise that. I'm not suggesting otherwise, and there's some assumptions that could be made. And to the point that the other witnesses talked about, 1,800%, and IRRs are pretty incredible. And then you could probably start getting a sense of what you put out in order to get that level of return is pretty amazing. You could put out for every dollar, you think about what the IRR has to be for every dollar what's coming back in. So yes, I could surmise that, but it's not necessarily that I'm going to learn that, because true or false, you give that to the judge, that third-party funding agreement, the judge could choose to redact certain information before it moves to the other side. Is that true?
Well, the way I read this, that the disclosure was being made to, let me go through and.
Sure.
Let me go through and find it. Let's see. All right, so,
Which line, just so,
let me make sure I'm looking right.
that's okay. I need someone to give me like a lobotomy. My head's hurting so bad.
All right, so I'm looking at lines 126 through 134.
Uh-huh.
And disclose and deliver a copy of the finance agreement to the following persons.
Right.
All parties to the civil action.
Right.
Okay, so that would be, I'm giving
That
it
would be-
to, I'm
yep.
I'm giving it to the party. The judge and the gatekeeper here,
Mm-hmm.
this bill makes me give it to the other side, and that's what I feel creates an unequal bargaining position.
Okay, so again, forgive me, I'm not a trial lawyer, and I did not say at a Holiday Inn Express last night, but my understanding is prior to, call it line 126, we start going into unless otherwise stipulated by the parties, and then we start going into, my understanding is there is a series of different things that can be asked of a judge before that type of disclosure occurs. As a matter of fact, I'm told that is almost normal course that when there's an interrogatory given, that there's a series of different objections that are made that the judge has to rule on. Is that just typical? I'm not asking you about the statutes. I'm just talking about we're in the courtroom, and when that's done, isn't it typical to just ask the judge to do certain things?
Well, we're talking about a lot of different things.
Sure.
Let's say typical, because you've got just general car accident cases.
Sure.
And I'm asking somebody, to identify the owner of the car, where they were that day, and those are not objectionable questions. When we get into this arena of mass torts, or
Yep.
trademark work, or trade secrets, that we're talking about something that is highly specialized, which there certainly can be. The purpose of litigation is to gain a business advantage. And that's where you have a lot of contentious litigation, but the parties to those cases are both sophisticated, and they've got sophisticated lawyers, and they're already fighting those fights to protect their trade secrets. So this is just not a bill we need in Georgia.
Well, the good news is reasonable men can disagree, right?
Agree, yes.
Yep. Thank you, Mr. Snipes. I appreciate it.
Okay.
All right. Vice Chair Reeves.
Mr. Snipes, under the Georgia rules of professional conduct, this whole notion of somebody other than the lawyer and the client having control over decisions about the case, that's already prohibited by the Georgia Supreme Court, right?
Completely.
And then also on third parties providing funds to a lawyer in litigation, there are Georgia rules of professional conduct about that, right?
Mine, and I should have, I didn't know exactly where we were going, but my understanding is that the rules governing client communications require the lawyer to let the client know about anything that can affect the outcome of their case.
And generally the rule in Georgia is if you take money from a third party relating to representation, your full duty is to the client, not to the third party. right?
Exactly.
And that's, I mean, there are detailed rules and comments on that rules on those rules promulgated by the Georgia Supreme Court that are mandatory on Georgia lawyers already. That's what makes us different from Minnesota and other cases where these problems have happened, right?
And the punishment for violation of that rule is disbarment.
Okay. All right, that's all the questions I see. The remaining speakers I have on this bill all are showing support of the bill, and I'll call you up one at a time. We're running long, and we got another long bill coming up after this pretty soon, so I want to get moving if we can. Brittany Hull, Clay Jones. Okay, and that, if you want to come up and say that on the record, that's fine too. So. So for everybody that's watching, if you just introduce yourself and who you represent, and then make your statement.
Yes, sir. Thank you, Mr. Chairman. Thank you, Chairman Jones, for bringing the bill. Brittany Hull with Georgia Association of Manufacturers, and we do, in fact, support the bill.
Clay Jones, I'm also with GA. I'm our Vice President and General Counsel, and we support the bill. So
Okay.
thank you for hearing it.
Yep.
Thank you all
Thank
very
you.
much. Appreciate it. Michael Gooden.
Oh, no, he already spoke. No,
Oh, he did?
that's
Oh, I'm
what
sorry. Oh, this is the,
Yeah.
that's right. I'm adding up too many here. So now we go over to Brent Walker.
Yes, sir. Thank you, members of the chair, members of the committee. My apologies. I am Brent Walker, General Counsel for the Medical Association of Georgia, and we support the bill, and we thank you for your consideration and the able testimony of the witnesses. And thank you to Representative Jones for bringing the bill, and we encourage you to support the bill as well.
Great. Thank you very much.
Thank you.
All right. Chairman Smith.
Mr. Chairman, you ready for a motion?
Yes, sir.
I move do not pass, Mr. Chairman.
All right. Any further discussion? All those in favor of the motion say aye.
Aye.
Any opposed?
Me.
Okay, the ayes have it. All right. All right, let's see. All right, next up, let me see if I can move some shorter bills out of here. I'm hoping. Yeah. Chairman Smith, let's do yours.
Don't worry.
And I got some circle. Come on in the room so I can see you, and I'll call you up here in just a second. All right.
Yes, sir.
Go ahead.
Yes, sir. Thank you, Mr. Chairman. I bring to you House Bill 1288. This is to prohibit municipal courts from holding sessions on our Juneteenth state holiday. For some reason, we left that out. I saw something on my calendar this past June, on Juneteenth, that had me in a certain court that I will not name. I show up, and 75% of the defendants in the crowd are African American. You can imagine the feeling that I had wash over me at that time on this very, very special holiday. And so, Mr. Chairman, I would have hoped that we'd have caught this beforehand, but, Mr. Chairman, I think if the state courts are going to be off on holiday, our municipal courts need to be as well.
All right. Vice Chair Reeves?
Motion at the appropriate time.
Well, I don't see any other questions.
Move to pass.
All right, got a motion and a second. Any further discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? All right, bill passes on the rules.
Thank you, Mr. Chairman.
All right. Let's see. I got Koya. All right, this is Representative Camp here. Oh, there you are. Come on up. All right, you have House Resolution 302, and if you would, the floor is yours. Go ahead.
Thank you. This measure was actually brought, let's see, I think first time in 2022. Last year it came to Judiciary, and it passed Judiciary. And did not make it over to, well, we passed in the House too. I believe it just didn't go over from that point. And it was recommitted. This is a bill. It's LC 500787S. And this measure provides for funds. Oh, I'm sorry. That is not the right number. I gave you the wrong number. Sorry. LC 50686S is in Sam. I apologize. This measure stipulates what happens to awards and unanticipated funds when they come into the state. And the beginning date on this is anything after January 1st, 2025. And it is a constitutional amendment. And it also stipulates that unanticipated funds in excess of $75 million shall be continually appropriated by the General Assembly. And I'm open for any questions.
Any questions? Not seeing any from the committee. And don't think anybody signed up to speak on the bill. So what's the desire of the committee? Motion and a second. Any further discussion? Hearing none, all those in favor say aye. Aye. Any opposed? All right. Going to rules.
Thank you very much, Mr. Chairman and committee.
All righty. And Chairman Perkle, come on up. This is House Bill 1295.
Yes, sir.
Floor is yours. Go ahead.
Thank you. Thank you very much. Did we need to wait on Chairman Corbett, or just go on through?
What was Chairman Corbett's part in this?
Oh, it's not motor vehicles. It was Title 40 bill. I thought we were motor vehicles, but this is Judiciary. My mistake. I'm so sorry. I am so sorry. I have House Bill 1295.
It's been a long day.
This is a lot easier than motor vehicles.
Thank you, Mr. Chair. I figured after the 25-hour debate that y'all had that a little bit of levity would be fun, and my kids are wonderful. They're what I live for. It has been. We talked about the honor of your life. It's been the honor of my life to raise my kids. But I got to tell you, they can be a little sneaky. When they were getting in their teens, they were real sneaky. And I made a pact with my friends. I said, if you ever see my kids engaged in behavior or in a place that would concern me, I need you to tell me. And I'll do the same for you. And the reason is because I can't manage what I don't know. It was important for me to have the information to make informed decisions. And that's what this bill does. This bill simply allows parties to inform juries when someone was not wearing a seatbelt in a motor vehicle accident. For me, so y'all have this fairness doctrine that you have through legal stuff, but for me, I'm just a farmer. Fairness to me is right and wrong. It's coming into a fight fair. If you trust juries, give them all the facts before they render damage awards or allocate fault. So Georgia law allows juries, as I understand, to be informed if a plaintiff was wearing a motorcycle helmet while riding a motorcycle, if they were speeding, driving under the influence, reckless driving, but not whether they were wearing a seatbelt. For me, just a guy, it defies logic. At church, when you hear about an accident, Sally was hurt in a bad car wreck. The first thing we asked was, were they wearing a seatbelt? Yet the jury does not have access to that most basic information. When a witness testifies in one of these cases, and so I don't know my way around the jury room much or in the courtroom much, but I've seen enough Perry Mason and Matlock to know that they say they are to tell the truth, the whole truth, and nothing but the truth. truth, yet we do not permit them to tell the whole truth. We do not permit them to comply with their oath, so help me God. We allow incomplete information for juries. One reason it's important to tell the whole truth is this. About 90% of Georgians wear a seatbelt. Yet almost 50% of the fatalities are unbelted. Juries without all the information would naturally assume they're wearing a seatbelt because they do, and it's mandatory. I was driving through a small town, South Georgia, this weekend, Coolidge. 10 points if you know where that is. And a prominent sign stated, seatbelt use, 97%. I ask you to vote for this bill. I don't know whether you trust juries or not. I'm positive that every one of you publicly will say, I trust juries. I'm also positive that privately some of you maybe might not be so sure. Regardless, I ask you to give the jury the whole truth and nothing but the truth. Take the gag off.
You ready for questions?
Yes, sir.
All right. Representative Kelly.
Should juries know how much insurance coverage is available?
So while I am not I've got a friend here that I would like to introduce. He's actually an author. I'm sure he's a great attorney too. I read a law review article he had from several years ago. Would you introduce yourself?
Well,
Would that be
just-
okay, Mr. Chair?
If I can, just philosophically, truth and nothing but the truth, does that encompass how much insurance coverage is available? The whole truth, nothing but the truth, does that encompass how much insurance coverage is available?
As it relates to whether or not, I'm not sure that would relate to how it would be, how they find comparative fault with a jury. I'm really not sure where that would enter into it, but there might be some more learned people here that could expound on that better. Yeah.
Okay.
What?
Oh, I'm sorry. I got more questions for you. Hang on. Who's first? Chairman Smith.
Thank you, Chairman Gunner. To my friend and former boss, good thing I've been paid in full back then. I didn't detect the answer there to my friend, the gentleman from the 16th question about whether that insurance coverage should be disclosed. And I want to see what you think about that because maybe I missed that, and I'm subject to that. I've had 5 ear surgeries. So hopefully it's still intact. But I wanted to see what you thought about that because in that line of disclosure, just wanted to see what you did think about that.
So currently, is that allowed to be included in there again? Is that allowed to be included? So when you're looking, would that have, can I talk to him or do I have to talk through you?
No, you're
Okay.
fine.
Okay. So when we're looking at allocating fault, would how much insurance coverage would that kind of be part of what that discussion would be?
I mean, I would say that if you disclose that, because you were asking about juries earlier, and
Yeah.
I'm glad you asked me this because certain areas of this state, and I've seen this in person, small towns, say, for instance, small county. Most of our counties are small relative to those around here, but you look at it, and a lot of juries are wondering, okay, we give this injured individual the amount that they're asking to be made whole, we're going to put Bobby Joe in the poorhouse. And they don't realize that Bobby Joe's not going to be in the poorhouse. Bobby Joe did what a responsible individual would do and has appropriate amount of coverage to cover instances like that occurred for them being at fault in a wreck or what have you. And so that's what I'm getting at. I mean, I understand where you're coming from. And I know your intent's sincere, but I just wanted to know whether you would be open to that disclosure as well, so they know that they're not going to be putting Bobby Joe in the poorhouse. They're going to be making this person whole. And so you get the full view of the facts with the disclosure of that insurance coverage.
Okay, as I understand what my bill does, but there again, I've got someone to kind of speak on my bill, that what I'm looking at is evidence admissible for mitigation of damages and assumption of risk and apportionment of fault and negligence and comparative negligence. And that is where my bill lies. I'm not trying to expand it to other areas. Maybe
Sure.
that's
Sure.
something that you might look at.
Sure. Would you be open to that kind of disclosure as a friendly amendment potentially?
So I have absolutely all the respect in the world for my friend.
Likewise.
But I cannot believe that that will be a friendly amendment to this bill. But thank you.
Okay.
Judge Scoggins.
Chairman Perkle,
Yes, sir.
knowing that I'm an old traffic court judge and I've fined many people $15 for not wearing a seatbelt,
Yes, sir.
do you know why I did that?
I suspect it's because it was a law.
It was a law, and it's for safety.
Mm-hmm.
So thank you for your bill.
Thank you.
Vice Chair Reeves.
Is it the right time for questions for you, or are you going to testify first?
I can do either. I'm happy to answer questions. I'm happy to give some prepared
Okay.
remarks as well.
We voted. Our what's name and firm and
Thank you,
Yeah.
Mr. Vice Chairman. My name is Jake Daly. I'm an attorney with Freeman, Mathis, and Gary. We have an Atlanta address, but technically we're in Cobb County. I'm also a member, of the Georgia Defense Lawyers Association, and I'm here on its behalf today to express its support for this bill and to urge you all to vote in favor of it.
good to see you again. Today we voted for the floor leaders and the governor's study committee on tort reform, and they're going to be diving into insurance analysis and questions regarding the legal system. And without that effort being done yet, do you have any data about differences in Georgia and Florida car accident claims, with seatbelts being admissible by a three-part test in Florida under limited circumstances? Are there any differences in insurance or claims in Florida and Georgia with it being admissible down there in some circumstances?
Honestly, I am not familiar with Florida's law on this topic.
Okay. And then Georgia does have the Daubert standard for experts, right?
Correct.
But right now there aren't any experts in Georgia who are Daubert qualified on seatbelt issues for car accident claims, right?
Well, there wouldn't be any that would be qualified in terms of being accepted by a court, since that's not particularly really allowed at this point. But I'm quite sure there are plenty who would be qualified to talk about seatbelt related issues. I mean, primarily the issue is going to come down to a damages question, and so it's going to be more of a medical issue, perhaps a biomechanical issue. But it's not, I don't think this is really getting into the area of having experts for the mechanics of seatbelts, unless that's made an issue in a case.
Well, the words on the paper, though, were causation, contributory negligence, and things like that, not damages. So,
well, where I'm coming from, yes, it's the evidence would be admissible for purposes of both liability determinations in terms of allocation of fault, which would also relate to how the damages awarded by a jury are allocated. But it's sorry, I just lost my train of thought there. It's also a medical issue, because the defendant in a scenario where this law is enacted does bear the burden of proving that whatever percentage or types of injuries are allocable to the failure to use a seatbelt. It's not that this evidence just comes in willy-nilly. I mean, that's not part of the bill, but I mean, in terms of the history of prior bills that have been enacted and the theory of responsibility for, burdens of proof and whatnot. I think it's pretty generally well accepted that the defendant would bear that burden in a world where this statute is law.
But seatbelt liability issues and damages issues, those would be matters of expertise that Dauber would apply to and experts would apply to, right?
Potentially. I mean, there are, not to get too deep into the weeds, but the Supreme Court has said that there are, medical questions and then there's medical questions. If somebody walks up to me and shoots me, point blank in the forehead, you don't need a doctor to say why I was killed or why I died. So there are some questions that the Supreme Court has said are, pretty obvious, and therefore you would not necessarily need an expert for, but others that you would. So I wouldn't categorically say no, but there are conceivable instances.
But you don't have any light to shed on seatbelt experts as to liability and damages here today?
No, because none have been used, and like I say, it's more a matter of, I think, a doctor saying, we can, with the help of possibly a biomechanic, saying, this person was ejected from the vehicle because he was not wearing a seatbelt. Had he been wearing a seatbelt, he would have sustained, bruising to his chest. Maybe he would have hit the steering wheel or something like that. But because he was ejected from the vehicle and catapulted, 50 yards through the air, and landed on a pile of rocks, that's why he died. So it's more a medical thing. I think that there would be plenty of experts.
That's what I'm getting to. I mean, there are instances where people get ejected who are wearing their seatbelt, right? I mean, this is an issue
pretty
that
rare.
Yeah, but experts would be able to shed light on that issue of expertise and accident reconstruction. Those are matters of expertise and Daubert, and we don't have anything here in front of us today on that, right?
And that would be, at least to an extent, that would be a product liability claim if a seatbelt failed in some way, which is an oddity today because, a plaintiff can bring a claim today for a defective seatbelt, but the defense can't say, well, he wasn't wearing the seatbelt. Now, it might be obvious if there's an ejection and you say the jury is told he was ejected from the car, they'll probably assume he wasn't wearing a seatbelt. But as you say, there's a possibility that it could be a defective seatbelt and he was wearing a seatbelt and was still ejected.
Thanks.
No.
If I could just gratuitously address the previous question.
Yes, sir.
I'd like to do that because the question of insurance coverage being disclosed to a jury is quite far afield of what this evidentiary issue is designed to achieve. This is something that's relevant to liability and how the damages are caused, that sort of thing. And we know that but for the existing statute, this evidence would be admissible. And we know that because every single case that was decided before this statute was enacted in 1988 allowed this evidence, held that it was relevant evidence, and also that it was therefore not prejudicial. Insurance coverage, on the other hand, has for eons, if not forever, been regarded by the courts as so prejudicial that we don't let the jury know about it, except in the one type of case in the direct action area in trucking litigation that's also got a bill pending somewhere in the legislature right now to amend that law. But there's a vast difference here because there's no prejudice to the evidence of a person's failure to use a seatbelt, but there is great prejudice to disclosing to a jury the amount of insurance coverage that a defendant has. Now, that's the short answer to those questions. The slightly more academic and long answer to that is, well, if we want to open it up to everything, then that would also include, does the plaintiff have health insurance? Why didn't the plaintiff use his health insurance instead of treating on a lien with a doctor who was willing to take take his chances on that. Is it also, you know, the comment was made that a defendant does the responsible thing by buying insurance, and we don't want that person to be bankrupted. Well, is it also true that a plaintiff has to do the responsible thing by having medical insurance or other types of insurance, as the case may be? I mean, there's a huge Pandora's box that could be opened if we want to talk about literally, you know, removing the gag to everything that a jury is precluded from hearing these days. There's a whole section in the evidence code in the relevance rules that excludes certain things because it's just considered to be so unfair that or so prejudicial that we don't want juries to know about it. Insurance coverage is one of those things. Evidence of settlement discussions is another. And so there are good policy reasons for excluding certain types of evidence along those lines, including the amount of insurance coverage that a defendant has. But there are no such considerations for evidence relating to the failure to use a seatbelt. This is the argument that the GTLA has advanced for many years since I've been involved in this issue, and I've never once heard anything other than a conclusory assertion that this would be prejudicial. There's no studies out there or polls or anything like that that says people, if they heard that a plaintiff was not using a seatbelt, that they would then decide the case on the basis of emotion or some kind of inflamed, you know, hatred of the person who didn't use a seatbelt. That kind of evidence does not exist. There's no consideration that that would be something that would happen here. And so there's no reason whatsoever to believe that there would be any kind of improprieties going on in a courtroom with respect to this evidence being admissible. As I said, it was admissible in Georgia courts before 1988, and it was only rendered inadmissible then just because of a legislative bargain. There was no consideration by the General Assembly that this was prejudicial and needed to be excluded. This statute came about because Speaker Tom Murphy would not allow the mandatory use statute to be passed without this statute being passed at the same time. So that's why we have this rule. It's not because somebody said there's a good reason to exclude this evidence. There is no good reason. One just sort of analogy that I've always given is there's no similar statute dealing with motorcycle helmets. According to the case law, therefore, the failure to use a motorcycle helmet is admissible. So we treat one safety device different than we treat another safety device. As the bill itself shows, there's also a discrepancy with child safety seats. And that has an exclusion in it for certain things, but not the same types of things as seatbelts. So we treat child safety seats, you know, differently than we do seatbelts and motorcycle helmets. Ultimately, this just comes down to a matter of just pure fairness. The jury should be entitled to know this information, and there's no reason to believe that it would be prejudicial in any manner. If there was a case-specific reason for believing there was prejudice, that could then be dealt with by the judge, like every other evidentiary issue is. But there's no basis for a categorical prohibition based on a non-existent prejudice. And I'm happy to take other questions.
Vice Chair Reeves.
I think that motorcycle helmet analogy goes back to the issue of expertise. If somebody has or doesn't have on a motorcycle helmet, it's either going to be there or not. That's not a matter of expertise. If you have an allegation that somebody wasn't wearing their seatbelt, you've got to have some extra expertise to determine, did they have it on or not, did it work or not, and how much worse is the injury based on a working seatbelt not being used, right? I mean, you got several layers of expertise that are needed, and in those product liability cases and accident reconstruction, you got experts there, right?
Sure.
And we don't have any of that here on this, right?
But there's no reason to believe that they can't be found. I mean, this evidence is admissible in other states, and so I'm sure.
And we don't have any evidence that's made any adjustment on the claims, on the value of the claims or insurance premiums. I mean, the last I heard in Florida, it's worse than here.
I can't speak to any effect on insurance premiums, but I mean, it all depends on the reporting that you would have for case verdicts and settlements. I mean, obviously, if there's a more extensive injury, then theoretically there should be higher verdicts and settlements, unless the evidence requires the apportionment. And bear in mind, this all comes back to the policy that this body has adopted back in 2005 with that tort reform package for apportionment of fault and the elimination of joint and several liability. I mean, that's all this is really trying to do, is to say who is at fault for each, injury or damage that the plaintiff has alleged to have sustained. And if the defendant can prove that this particular injury or this amount of damages was caused by the failure to wear a seatbelt, why shouldn't that defendant have that ability, given that this body has decided as a matter of public policy that every party should only pay for the damages that he or she caused? That's all this bill would do is sort of empower, if you will, the apportionment bill. But there's no reason to believe that experts wouldn't be available, and but they're not even necessarily required for all of those issues that you bring up. Was the person using it? That can be decided by eyewitness testimony, the police officer, for example, or other witnesses. It could also be decided by the evidence of I think it's referred to as the load on the belt itself. When it shows like those marks on the belt that indicates that that the mechanism caught on it and pulled on the fabric of the belt, then that something happened. I don't know about experts for whether the person was using the seatbelt or not. That's just going to be regular evidence, unless you need somebody to testify about the load marks on the belt. But there's no reason to believe that it would be too difficult for some reason to have those experts. And that's another argument that's been made against the seatbelt bill in the past, is ratchet up the cost of cases. Well, that only happens if the case warrants it, just like any other case. I mean, there are plenty of cases that are so-called low-value cases that you could hire an expert for, but you choose not to, simply because there's only a certain amount of damages at issue, and it's not economically feasible to do that. But if it's warranted, trust me, both sides will do it if it's warranted in the case.
All right, I see no further questions. I don't think we have any witnesses, do we? Oh. No. Representative Alden.
Thank you, Mr. Chairman. I listened to what you had to say, and I've never done these cases on either side of the V, so it's outside of my expertise. But I find it a little bit hard to believe that this wouldn't come in. If I were a defense lawyer, wouldn't I try to say that they broke the law, and because of that, they shouldn't be given anything, even if, let's just say that I'm at a stop sign, I'm parked, my phone falls off of the thing to comply with the hands-free law. It falls down, so I'm stopped. I undo my seatbelt to reach over and grab it, and then while that happens, somebody comes smashing through, and then I'm deceased. I can't explain that moment. All the other time I was driving, I had my seatbelt on. I can't then explain at that moment I undid it. You would just hear that I didn't have it on at the time of the crash, even if I did nothing wrong and wasn't the party that was negligent and the other would. But I would think if I was the defense counsel, I would say that person didn't have the seatbelt on. That person assumed all the risk of damage, injury, and not a dime should be awarded. Or am I looking at that wrong?
I mean, that could be an argument to make. Biomechanically, it might be possible to show that you were doing something other than sitting upright in the driver's seat, and that might then lead to, an argument or at least other evidence that maybe the seatbelt wasn't on, but maybe there was a reason for that, which does not then relate to whether you were wearing it, while driving. The other part of the argument, though, I mean, sure, a defendant might want to go for the gusto, so to say, and argue that totally eliminates any recovery, but that's probably not likely to be successful. I would think.
Why?
In most cases, because the accident still occurs. I mean, it's pretty hard to say that a person. It's theoretically possible. I'm not trying to say it's not, but it'd be pretty difficult to say that if somebody slams into the back of your car, that you suffered 0 injuries as a result of that, but for you're not wearing a seatbelt. So there will almost always, I would think, be an apportionment of the fault between the person who didn't wear the seatbelt and the other driver, and therefore an apportionment of the damages to be awarded by the jury. But I mean, it is theoretically possible that a defendant could prove that no injuries would have occurred, but for the failure to wear the seatbelt. And if that's proven, then I mean that would just be like any other case where the causation element is proved by the defendant in that manner.
Okay. All right. Thanks.
Let's see. See no other questions for y'all. I do have a Brandon Peak, I think, that's signed up to speak on it. All right. Come right up here in the hot seat.
I tell you, buddy, it's hot now. I'm ready.
Mr. Chairman, members of the committee, my name's Brandon Peak. I'm a lawyer at Peak, Wooten, McDaniel, and Caldwell in Columbus, Georgia. I'm here on behalf of the Georgia Trial Lawyers Association. Just as a matter of procedure, this is the exact same bill that has failed to pass the Senate 4 times since 2019, the exact same language. And there's a good reason. And that good reason is that the fundamental problem with this bill is that it attempts to shift the focus from people who have caused the crash and hurt innocent victims to blaming the people who were hurt in the first place. It would literally allow a drunk driver to blow through a stop sign, hit a grandma on her way to church, and then receive a defense verdict on the basis that she was not wearing a seatbelt, is at least 50% at fault for not wearing the seatbelt, and as a result of the 50-50 rule for apportionment in Georgia, they get 0 damages. That's what this is about. It's about shifting the blame from people who cause wrecks to people who are innocently injured. I want to address some of the questions. I know where Coolidge, Georgia is. It's between Moultrie and Thomasville. Let me tell you about a case I got in Thomasville right now. A farmer, like Chairman Perkle, driving his John Deere tractor down towards Tallahassee in Thomas County, gets rear-ended by a tractor trailer and gets killed. John Deere tractor has a little tiny seatbelt in it. Do you think that would have saved his life as a result of getting rear-ended at highway speeds by a tractor trailer? No. Right now, that nonsense doesn't come before the jury. There's not a mini trial associated with trying to blame the farmer who got hit in the rear, doing nothing wrong, lawfully driving down the road. But that's what they want to do. Bobby Lee Cook said, once you throw that skunk in the jury, the smell gets on everybody. That's what it's about. It's about victim blaming. So there are a lot of things that are kept out of evidence. Your Honor knows from previously serving as a judge. You don't get to tell the jury that the police officer cited the defendant for blowing through a stop sign. They don't get to know that. They don't get to know that about any of the citations that's issued by law enforcement. They don't get to know what a terrible driving record that the person has, and that they got 5 prior DUI crashes and this is their 6th. They don't get to know about those things unless there are limited circumstances available towards punitive damages. That's what the rules of evidence are about. They're about keeping certain evidence out, even though it has marginal relevance. It's determined to be so prejudicial that it ought to stay out of evidence. And so, the thought about give them all the facts, well, the rules of evidence are there because we don't tell juries everything about everything. If we did, we'd tell them the police officer cited the defendant for blowing through the stop sign or running a red light. I want to address the data and where Georgia stands relative to its peers. We're one of 26 states that have this same law prohibiting seatbelt evidence from coming into evidence. One of 26. We're in the majority, the vast majority. Now, interestingly, there are only 3 states, based on our research, that allow unfettered admission of seatbelt evidence to come in. And guess which one of them is? California. This may be the only bill in the Georgia legislature where you're being asked to make Georgia more like California and less like its peers. That's what this would do. There are several other states who have hybrid formats where the seatbelt admission comes in very, very limited circumstances with very, very specific limiting instructions granted by the trial judge, or only in certain types of cases. That's not what this is about. It's not about just in damages. It's about liability as well. Now, there was the thought about, well, it may be really difficult. We'd have to have some there to get this into evidence. No, you don't. All you'd have to say is the other driver get up and say, I saw Mr. Peak up walking around after the wreck. He didn't have a seatbelt on. I don't think he had his seatbelt on. Based on that alone, it becomes an evidentiary issue where this would be triggered. But what's the first thing that we all do when we get in a wreck, unfortunately? And we're not dead. Usually we reach over, unbuckle our seatbelt to check on other people in the vehicles with us, to make sure our wherewithal is okay, to check on the vehicle to make sure it's not catching on fire, to go render aid to somebody else. And then somebody walks down the road and says, I saw Mr. Peak up there walking around to the scene, didn't have a seatbelt on. Well, now you've triggered an evidentiary issue. So how do we disprove that? There are 3 ways. Eyewitness testimony. People show up at wrecks. They're worried about helping other people. People are in shock. These are bad things. They're not walking around keeping notes about who has their seatbelt on. Now we're going to introduce a swearing contest about whether somebody has their seatbelt on to shift the focus from the trial away from who caused the wreck and who's responsible. That's what that's really about. The second way is black box data. The ECM modules that you talk about on airplanes. Well, those principally only go off when the airbags go off. So when the airbags don't go off, lots of times that module won't even capture the seatbelt use. And then for older vehicles, they may not even be equipped with the ECM modules. And we all know, unfortunately, there are a lot of used vehicles on the road right now because of the price of vehicles in the state. And then if they do have the ECM module in the vehicle, well, my client's in the hospital. They're not thinking about securing their vehicle. So the insurance company goes and picks up their vehicle and moves it to a Copart, and it either gets crushed or sold at auction. So how are we going to get that evidence? Are we going to amend the bill to make Copart and IAA hold the cars for 2 years till we can get the black boxes download? That's the only way you can ensure access to that evidence, if it's even there. And then it costs $500 to $1,000 for a download. And the third way is through this biomechanical engineer, that was discussed, which is essentially people who come in and give their opinion based on something that they believe someone did or did not have their seatbelt on, and they do or do not believe that it would make a difference. Well, those people in Metro Atlanta cost about $400 or $500 an hour. They don't just give their opinion based on that. It's going to be $5,000, $6,000, $10,000. So now you've complicated a straightforward road wreck case that happens every day in Georgia, made the plaintiff spend $10,000, created a side issue that has nothing to do with who originally is responsible for causing the wreck, and for what? Because they know that if they force the plaintiff to spend that money, it's going to come out of the bottom line of the plaintiff. I mean, ultimately, the way there's a lot of discussion about contingency fee contracts earlier, and on behalf of Columbus, thank y'all for mentioning Synovus so much. I think that they may feel sponsored by the previous session, but a contingency fee agreement says you pay your attorney XYZ and then you pay for your remaining expenses. Well, if I have to spend $10,000 to go hire a biomechanical expert for this, that ultimately comes out of the plaintiff's money. And so, that's a problem. So, those are, I'm happy to answer any questions. All of us agree that having the seatbelt on is a good public policy thing in the state of Georgia. We fully agree with that. And the state does a good job at 93 and 94% of getting people to wear their seatbelts. But in the limited circumstances where somebody doesn't have it on, you shouldn't punish that person who's innocently involved in a wreck. They're not going to be looking at this legislation and say, I'm going to wear my seatbelt because 5 steps down the line, I may not be able to that may be introduced into evidence against me in a wreck that I don't foresee will ever happen. So I'm happy to take any questions that the committee has, but we would respectfully request that this bill be voted down in committee. And there's a good reason that it did not pass the Senate the prior 4 times it was over there.
All right, call on Vice Chair Reeves.
I hear Morgan & Morgan commercials when I'm driving to and from Gwinnett County with my seatbelt on, and they say they're the world's largest injury law firm. They're headquartered in Florida, and they've got, seatbelts are admissible there, but you got this 3-part test. Do you know if car insurance premiums are lower in Florida, and do you know if claims have a lower value in Florida than they do here based on that seatbelt difference?
I do not practice in Florida regularly. I know the seatbelt standard for admission is different. Based on the number of lawyer billboard ads in Florida relative to Georgia, they even have more than we do. And so I would suspect that they're there for a reason, because those claims are more prevalent in Georgia. But Florida, excuse me, but I don't have the direct answer.
I read an article last week about car insurance premiums here in Georgia that the AJC did, and they talked about theft and crime. They talked about repair expenses. They didn't mention the seatbelt issue, and I know we voted for the study committee today, and we may have more data at a later date. But let me ask you this: standard pattern jury charges, did they prohibit the jury from considering the question of seatbelt?
It's usually not in the charges because it just doesn't even get to that point.
Don't you think they're talking about it in the jury room anyway?
Anecdotally, yes, I do, and from doing focus groups and other things.
Mr. Chairman, I was going to give this distinguished gentleman from Columbus a hard time about how God's company is so much better than Echo Company, but at the appropriate time, Mr. Chairman, I'd like to make a motion.
All right, let's see if there's any other questions for this witness. Seeing none, and I don't think there's anybody else to speak on the bill. All right. What's the, go ahead.
You want to say something?
You want to?
Shoot you out.
All right, well, come on up.
Heck yeah. I'm not gonna let my lawyer
I'll give you a rebuttal.
My
Yes, sir.
Stars. I'm not.
Sure.
Yeah.
But keep it short.
I will. I understand what happens when you go long. And there again, I'm really not sure what impact and as it deals with insurance rates in Florida. I have no idea. But I do know there's a bunch of factors to include. We've got different drivers. They have much higher levels of uninsured motorists in Florida for whatever reason it is. I have no idea. But it's hugely bigger in that area. What my argument comes down to is fairness. It comes down to if a driver can be cited for not wearing a seatbelt and is involved in an accident, can be cited for not wearing a seatbelt, and yet can get a pretty significant receive injuries resulting from the lack of seatbelt use, and juries actually don't look at that or can't look at that. To me, it's just a fairness issue, and it's been Fran would like to finish up.
But just to build on that point, since you're the one asking the question about that, Representative Reeves, I would say this is not at all about a premium increase issue or anything like that. Comparative negligence is already the law of Georgia. The question here is simply what conduct or behavior by the plaintiff can be argued to be comparative negligence. And so that's where this is purely a fairness issue, because the plaintiff is doing something that is against the law. And think about all the things that are against the law that are admissible in trials. There's a lot, and that's why we have a doctrine called negligence per se. That's exactly what that is the violation of a law is deemed to be negligence. And that's all that this bill is about. The notion of defendants trying to escape liability is just not a convincing argument, because, as I've said, it's doubtful that the failure to wear a seatbelt would be an absolute defense. I mean, as a defense lawyer, I don't believe that would be true very often. I mean, like I said, it's conceivable, but it's not likely to be true very, very often. All this is an argument that we make all the time in all kinds of cases that currently exist, which is the plaintiff did something that was negligent. That's what this is. There's no trying to escape any liability here. This is what we argue in cases all the time already. It's just this particular conduct by the plaintiff we can't argue, because there was a deal struck, some 30 some years ago that has nothing to do with the normal standards for admissibility of evidence. That's what this bill would restore, is those normal rules.
No.
And I would like to defend the honor of the House. Just because the Senate has not voted on your bill positively 5 times, we've each had a bill in the Senate that they have tragically neglected to take up. So on behalf of my House members, that should not be a disqualifying statement.
All right, thank you. All right, Chairman Smith.
Yes, sir, Mr. Chairman. Got a motion?
Yes, sir.
I move do not pass.
All right, got a motion do not pass in second. Any further discussion? All those in favor say aye.
Aye.
Any opposed? So we got 2 opposed. Raise your hand, those that were in favor of it. On do not pass, right. All right, it gets a recommendation of do not pass.
All right. Well, thank you anyway.
Thank you. All right. Let's see.
1017 or 1292?
I better do 1017. I've had Representative Seabaugh has been very patient.
He's been squatting.
Okay. I do.
But he did look like he was enjoying himself.
Okay, this bill has been before the committee before, and as a result of that, I think we had some amendments to it or changes.
We did.
All right. You want to go over those with the committee?
I will be happy to. Good morning, everybody. I apologize to you. I think I wore the suit to work yesterday. But thank you again for hearing this bill today. I just want to be clear on this bill and what we're addressing. This bill is addressing squatting in Georgia with the intent to expeditiously remove squatters from a property and restore the property back to the rightful owner. This is not a tenant issue. It is a squatter issue. In Section 2 of the bill, which I don't believe was in the bill the other night, Section 2 gives the magistrate court authority to conduct proceedings against intruders and unlawful squatting violations. In Section 3 of the bill, we added a new code section, 16.721.1, relating to criminal trespass and damage to property, defining squatting, defining what happens when someone is accused of squatting. We define what happens when someone submits fraudulent documentation to the court, and we define what the penalty is for a person found to be guilty of squatting. In Section 4, the bill defines what happens when someone knowingly files fraudulent statements or documents into public record and what the punishment will be. Now, squatter is defined as a person who unlawfully occupies an uninhabited building or used land. And a tenant is a person who lawfully occupies land or property rented from a landlord. So it's two separate issues that we're addressing here. On Section 5, pages 4 and 5 of the bill, it lines 84 through 98 describes what happens when the rightful owner of a property submits an affidavit for demand of possession against a person living on the property. The person in possession will have 7 days to vacate the property unless the person, I think we changed that to 3 days. If we didn't, we need to. To vacate the property unless the person is in possession and tenders to the sheriff or other post-certified officer a counter affidavit claiming legal right to the possession of the property, at which time both parties will remain in place. On line 84, the code is changed from a time frame of earliest possible day to turn the person out to 3 days to turn the person out. It also adds, in addition to the sheriff being able to turn a person out, we included a sheriff's deputy, constable, marshal, and other post-certified peace officer. In Section 6 of the bill, it revises code again to allow the sheriff, a sheriff deputy, constable, marshal, or other post-certified officer to administer the oath to the person in possession if she desires to tender a counter affidavit. And in Section 7 on pages 5 and 6, it amends code relating to procedure on submission of a counter affidavit in trial. Those were the major changes. I think we have some friendly amendments too. We made some changes during session today that I don't think made its way into this. So I'll ask Representative Silcox to make an amendment if she so chooses.
Well, hang on just a second. Section 4, which is the new criminal statute, it basically is a misdemeanor, but it's describing acts that elsewhere in the criminal code are considered felonies. So,
Right.
Is that something you'd be willing to change?
I'll refer to Representative Reeves
All right.
if I can.
Mr. Chairman, Representative Seabaugh and I worked with Legislative Counsel to try to straighten out this 1850s intruder civil statute in Title 44 with our criminal proceedings. The Title 44 proceeding will be in magistrate court, and so we had all the criminal matters relating to unlawful squatting to be put in magistrate court as well. We worked with prosecuting attorneys counsel, and I appreciate their hours of work on this, and we had to make the decision, do you keep it in magistrate court or do you move it over to state and superior court? And all things considered, since we've got this old statute on the books about the eviction part of squatting and intruding, let's keep the criminal proceedings in magistrate court. The landlords, the property owners, want to get these squatters out, and the criminal part, we do want to make it a crime. This bill makes it a crime, but we kept it at the magistrate misdemeanor level for those reasons, because we have the
And the
eviction.
PAC was okay with that?
They said you've got to go one of two directions. So you would have more of a magistrate level prosecution than a superior court felony level prosecution in these cases. You would have solicitors doing it rather than the DA's office.
I get that, but I can't imagine having two different codes that conflict with each other, especially in the criminal code like this.
Well, we have
We're
created,
talking about the same behavior being treated two different ways.
but this statute is a new statute on unlawful squatting.
I get that, but you're still going to have in the code two different punishments for the same conduct. That's the problem I have with
Is the, I'll speak.
Yes, sir.
My understanding was the criminal intent was when they submit the false affidavit, and that the magistrate court could render that over to the superior court for felony charges.
And
I'm just going by what I'm reading here.
Chairman
Files,
Gunn-
enters, or records document of some sort.
Correct. If someone fakes a lease or provides false sworn testimony, that goes in a different direction. But all of the unlawful squatting, the unlawful presence, that would be a misdemeanor. And another problem that this bill is solving is it has become prevalent in law enforcement to say squatting's a civil matter. This makes it clear, here's your crime, and then here's how to pursue the eviction on the civil side. We did the best we could to extricate the situation and provide both a criminal consequence and to get the squatters out.
All right. Judge?
Okay, thank you, Chairman. When we vetted this bill earlier, I thought we were trying to, basically get this thing going in the right direction all at one time, and that's why we kind of agreed, I think, to keep it in the magistrate court, kind of like county ordinance violations is the way they do it. And if they are issued a citation and they get out of the house, basically, and there's no other issues, it remains in the magistrate court. But if they refuse or they present a fake lease to the court, then I thought we were on the same page. At that point in time, the magistrate court could bind the case over to Superior Court and order the person arrested and carried to jail and post a bond for a criminal.
I think that's the only way to do this, and that this shouldn't be in this package here. The misdemeanor shouldn't be even mentioned here, because what that conduct is felonious conduct that goes up to the Superior Court. So that would be outside what we were trying. What I thought we were trying to do in 1017 was to deal with the squatter,
Yes.
and get them out.
Yes.
All right, getting arrested on a felony might be one way to get them out, but
But
I can't see leaving it in the magistrate court as a misdemeanor. The same conduct that when you forge a document, a deed or whatever that says, this is my property when it's not, that's a felony.
I think this was designed, I think, by Representative Sebo to try to get them out of the house as soon as possible, and to do it with a citation. And if they jump through the hoops, so to speak, then it remained in magistrate court. They paid a fine. They were out of the house in 7 days. That was the goal. Is that right, Representative Sebo?
Right. So if they want to jump through the hoops and they submit a false affidavit, the magistrate court has 7 days to determine if that's a good lease or not.
Mm-hmm.
Once they determine it's a bad lease, they issue the writ to take the property back, and then they can turn that over to the Superior Court or they can charge them with a misdemeanor and then turn them over to Superior Court for false swearing.
Okay. At this late hour, I'm gonna I'm gonna hold this bill. We still got time to get it out. It needs some additional amendments to it, but this issue, to me, is a stopper. We're not gonna go forward with it at this time. All right, now, Representative Okoye, you still here? Yes. I'm sorry about that, Dad.
It's all right.
Yeah, I'm sorry. If I'd known that this was there, I would have warned you ahead of time, but, okay. Yeah. I know next time I'm gonna have witnesses on it, because we'd already done that. No, it's, Representative, you've been very patient. I do appreciate it. Sorry you were the last one to be called up. If you would please go over your bill and tell us what it does.
Thank you, Mr. Chairman. This is a very hot seat to sit on. But I brought some water. I doused it. So, but anyway, thanks, members of the committee. I was watching TV not too long ago, and I saw news about a gentleman's house that was sold, and he wasn't even aware of it until the new owner came and asked him to vacate the house or pay rent to him. And this man was on dialysis and could barely afford to even pay his mortgage. Now he has to still pay that mortgage, pay rent in a house that he owned. And I looked into it, and this has been happening many times over here in Georgia and across the nation. And it just wasn't, it didn't sit well with me, because home is really home. And for you to sit there and somebody comes and tells you to get out of your home, that he now owns it. Imagine the shock. So it turns out that what has been happening is that when you go to file a deed with the clerk of Superior Court, they would not ask you for ID. So, I can come under any of you's name and file paperwork that will take your home, your houses away from you. So this bill is to stop that. And this bill is to also make sure that should that happen, that the owner has recourse. Because right now, from what I understand, it will take years for you to get your house back if that happens to you. So I know it's been a long day. I can go on. And of course, I want to thank my friend Matt. If you have a legal question, ask him. But anyway, I would ask the committee to please help fellow Georgians by approving this bill. Thank you, Mr. Chairman.
All right. Representative Kelly.
I think this may have been Representative Oliver, but I do have a question as I'm reading through the substitute.
Mm-hmm.
I've had a friend who has had a lien recorded on a property that is never, and he has no clue who the guy is. Hasn't had any work done. Just guy filed a false lien on his property, And I'm looking at section 2 and I'm just wanting y'all, some smarter lawyers than me, tell me if y'all think that may encompass that too. Maybe where it says 153 may bring an action against an individual who has knowingly filed, entered, or recorded, or caused to be filed, entered, or recorded any public record of false or forged deed or other instrument purporting to convey the owner's interest. I'm guessing it's just it doesn't cover liens, but I'd like it to maybe cover liens if we don't already have something like that.
That'd be the Liz Pendon's docket. Is that where the
it's
lien
under a
was?
mechanicsman's lien is what it's actually.
Yeah, but it would be registered in the Liz Pendon's docket.
Yeah. That doesn't have as much to do with this. It's on my mind, and since Virgil Oliver had already got recognized over here, I see some moment.
Vice Chair Reeves.
Mr. Chairman, I want to thank the clerks for providing a lot of input, and we did narrow the language in a way that in their interpretation is mainly aimed at these conveyances or deeds. In the lien statute, there you can file a notice of contest to the lien, and if they don't go confirm that lien within a certain amount of time, the lien is cleared. The clerks provided a lot of good revisions, including one that narrowed the language that addressed the situation Representative Okoye saw in Gwinnett County of senior citizens having false deeds filed that purported to convey an interest that they did not participate in, and that's where that came from. And we also gave some language to lenders who define that, and y'all are good with this language, right? Thank you.
Okay, the confirmation process on liens filed in Liz Pendon's is 7 years, is that right?
I believe if someone files a lien against your property and you file a notice of contest, I think they have 90 days to file a suit to confirm it.
Yeah, but you got to know about it. It's still alive for 7 years sitting on there if you don't deal with it.
A materialman's lien, I think they have a year total, but if you file a contest, it expires quicker.
It's been a long time since I've done that.
Now, a security interest, yes. If somebody files a false security interest against your property, this bill would apply, but it's the problem in Gwinnett and apparently in South Georgia and Senator Goodman's district also, fraudsters are conveying property owned by senior citizens without the senior citizens being involved.
All right.
Yeah.
Representative Oliver.
Thank you for this bill. This is a good idea because there is a lot of creative fraud going on about filing deeds. I have a narrow question about the difference between you using a representative of an insurance agency but not using, this is on lines 23 to 25, but not a representative of an attorney. I file deeds. I don't ever go to the courthouse myself. Right. I send people who we call, I don't send a paid courier, but I have a guy who used to be a paralegal that I send filing things, and I send my paralegal, and so it seems to me that we ought to mirror the language that's kind of with the bank or with the insurance agent, that a representative, I don't care whether we use the word agent or representative, you're using the word representative of an insurance agency on line 23, but I'd like to offer my paralegal doesn't have to.
And I think Representative Okoye and I, that would be friendly, but right. I would mention that the clerks, we put the term self-filer in this bill because the clerks have three categories. They have trusted filer, they have representative of a trusted filer, and then they have self-filer. This addresses the self-filers who are not a trusted filer or a representative of a trusted filer. So most attorneys' offices and their staff are a trusted filer or a representative of a trusted filer, and they would not end up being a self-filer. But since we set attorney in there, I think that's a good amendment.
Happens frequently. You told me something I didn't know, but maybe the clerk could tell us how they would like us to address that issue. I never heard self-filer versus trusted filer.
Stay seated if you want.
I hadn't either until
we all learn things.
Yes, ma'am. Greg Allen, Clerk of Superior Court in Forsyth County. Self-filers, if it was on the court side, that would be people referred to as pro ses that are doing their own, conveying their own property over. one thing we found, at least empirical evidence in my court from last month, Forsyth County's pretty economically booming, so I get a lot of real estate filings. I had 4,609 real estate filings. 4,222, 91% of those were all electronically filed. So, and for anecdotal evidence, we had a fraud case in Forsyth County, and the sheriff's office investigator contacted me and myself and the clerk's authority were able to give them information they needed off what that person had submitted electronically. And the investigator said, I don't need anything else. I have everything I need from you. So we're capturing that information needed electronically for the investigators to go forward with the investigation and hopefully a successful prosecution of people committing this fraud.
Okay. All right. Vice Chair Reeves.
Clerk Allen, when we were going through the trusted filer and the self-filer issue, was mail-in deeds, was that something you saw as rife with fraud, and that's why we put the electronic filing for the non-lawyers and people in there?
Yes, that's where we're going to catch them, or hopefully catch everyone, is when they have to give us a lot more information electronically, and we can trace that back a lot easier, or the investigators can, than simply something somebody's mailed in.
So this bill cuts out mail-in deeds by non-lawyers, by these fraudsters, and they have to e-file in a way where they're given a lot of information about themselves where they can be tracked down by law enforcement.
That's correct, and they can e-file either at home or at the courthouse, so we're not preventing anyone from recording a deed at all. They have the option to come to the courthouse, or they can do it online anywhere they'd like to.
Thanks for your work on this bill.
Thank you.
Okay. Any other questions by the committee? Anything else y'all want to tell us?
Just wanted to thank these guys here. They were right on it. And thank you for your help.
All right. Got a motion? Got a second? Are there any amendments? Representative Kelly.
I suggest that we amend line 25, following the word attorney, with the language or representative of an attorney licensed to practice law, or representative of an attorney licensed to practice law in this state. So the amendment would go, and I'm happy to get a correction from the clerk. So it would read, an attorney licensed to practice law or a representative of an attorney licensed to practice law in this state. The new language would follow law, if that's acceptable to the clerks.
Yes. Says one more time.
Following the word law on line 25, or representative of a attorney licensed to practice law.
Got something kind of in the same vein, maybe amendment.
All right, so this will be the Oliver amendment.
And he's offering an amendment to the Oliver amendment.
Okay. Before we make it official, then let's hear that. So we'll call it all the Oliver amendment.
Just out of consideration, I thought that maybe we ought to include realtors in this as well. And so I would just insert under just add on under Representative Oliver's amendment. I would just create a new 3 and renumber down through, and the language would just read a new 3 licensed under Chapter 40 of Title 43, which is the realtor language.
Licensed what?
Under Chapter 40 of Title 43.
Brokers.
And if that is an amendment to my amendment, it's acceptable to me, Mr. Chairman.
Okay.
And then you would just renumber going down.
What was that chapter number again?
Chapter 40 of Title 43.
40 in Title 43. All right. Let's see. That'll be the Kelly amendment.
Yeah, Kelly amendment to the Oliver amendment.
Well, you're okay. You're setting out a whole new line off of that. We'll combine it into one. How often do real estate agents file a deed or something? Okay. Yeah, take 18. Mm-hmm.
Hey, sir. Betsy Bradfield with the Georgia Association of Realtors. It's not 100% common practice, but it does happen. Not every single closing has to go through such an arduous process. So we do have real estate agents that do file deeds on behalf of their clients.
Have the client or the attorney that closed the...
If there's a closing, yeah, the closing attorney also files the deeds, but there are some transactions where the realtor, the real estate agent, helps file the deeds.
Okay. Thank you.
Thank you.
I don't know. All right. It's there. What do I know?
If they don't, we won't have to worry about it. But if they do, we're going to let them keep doing it.
All right. Yeah, I don't think we do. Do I have a motion?
Oh, yeah, we do. Yeah, we did. Okay, sorry. Yes.
All right, so we got a motion and a second to the Oliver Kelly amendment. Is that right? Yes. Okay. All right. All those if there's any further discussion? Any other amendments? All those in favor of the Oliver Kelly amendment, say aye. Aye. I'm getting tired. All those opposed, say no. All right. Amendment passes. Any further amendments? Any further discussion? Hearing none. All those in favor of the passage of this bill, say aye. Aye. Any opposed? Your bill's going to rules. And we're adjourned.